so that the board's proceedings will not be interrupted. Each appeal has limited time to make their cases, and we wouldn't want anybody's time to be interrupted by these avoidable noises. So thanks in advance for your help with that. In each of today's public hearings, the board reviews the correspondence that's been submitted in support of and opposition to each of the cases. The board reviews site plans, maps, photographs, and other documents that comprise the entirety of the case record, as well as correspondence from and recommendations from other government agencies in their review of these cases. In each of the hearings, staff will present a short presentation at the outset of a hearing for the board's consideration with regard to the case file. At the conclusion of the staff's presentation, an appellant will then have the opportunity to come forward and make the desired presentation to the case. After the appellant's presentation, the board would hear those wishing to join the appellant and speak in support of that case. Once those folks have had the opportunity to make their desired presentations, opponents would have a chance to come forward and speak to the board as well. After the opposition presents its testimony, an appellant would still have the opportunity to present rebuttal testimony if they wish. Under our BZA rules, the appellant has 5 minutes for a presentation if the case is uncontested. In contested cases, however, BZA rules allow for 10 minutes to each side to make the desired presentations. It should be noted, in the spirit of absolute clarity, that's 10 shared minutes, not 10 minutes per every person that might want to speak on a matter. So we encourage folks to divvy up their time with their neighbors accordingly in advance. For appellants that might wish to use some period of time for rebuttal, that's going to come out of the original 10 minutes, so allocate your time accordingly. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, namely Section 17.40.180. All of the section numbers to which we refer today come from the Metropolitan Code of Laws and the Zoning Code. The Zoning Code was adopted by the Metro Council and became effective on January the 1st of 1998. I'll introduce the entire Zoning Code and make it part of today's record for each of the hearings. The Metro Code requires a record of our proceedings. Because BZA meetings are recorded for public television, it is imperative that anyone wishing to come forward and address the board during one of the public hearings come to the front of the room to do so, use one of the microphones, introduce yourself by name and address, and then make the desired presentation. We're happy to have you here and happy to have you participate. You just have to do it on the record if it is to be part of the case. The Metro Code requires 4 of our 7 board members in order to establish quorum. With 5 present at this time, we have quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that 5 or more members are present and an appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within that 30-day window shall be deemed denied by operation of law. Pursuant to the board's rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the original hearing date. Additionally, an aggrieved party may file a motion for rehearing within the same 60-day window of the original hearing date, pursuant to the terms outlined in the BZA's Rules of Procedure. After that time elapses, the board's decision becomes final, and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you applied. Failure to do so would set you back at square one. A permit must be obtained within 2 years for a board approval to remain valid. It should be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in the proper order. Appellants have been notified by certified mail, and all legal notice requirements have been met for the cases today. Here at the outset of the meeting, we will make a couple of preliminary announcements for the benefit of the board and for the public. 2 cases originally docketed have been withdrawn from the docket. The first is case 2017-404 involving the property at 3325 Dumas Drive. That case has been withdrawn and will not be heard. Additionally, case 2018-013, that's on page 6 of your docket, involving the property at 1023 11th Avenue North has also been withdrawn and will not be heard by the board. The board utilizes a consent agenda. One board member reviews the record for each case prior to today's hearings and identifies cases where the appellants met the criteria for their requested actions. If the reviewing board member determines that testimony in the case would not alter the material facts of that case, then the case is in fact recommended to the board for approval. We'll enter into the record those cases that have been so recommended today. And if anyone is here in the audience in opposition to one of the cases identified for consent agenda, just identify yourself by raising your hand. Make sure I see you. We will remove that from the consent agenda, and then the case will be heard in its regular order. The first case recommended for consent agenda is item 2017-399, involving property on 54th Avenue North, and a request for special exception and variances from skyplane, front setback, and landscape buffer. That case has been recommended for the consent agenda. Is there anyone here in opposition to the case number 399? Seeing none, the second case recommended is 2017-422, involving the property at 6212B Morrow Road. Is there anyone here in opposition to case number 422? Seeing none, the third case recommended for the consent agenda is 2018-011, involving the property at 848B Clayton Avenue. Is there anyone here in opposition to case number 011? Seeing none, Mr. Chairman, those are the three cases recommended for today's consent agenda. Again, by way of recap, that's 2017-399, 2017-422, and 2018-011. We would solicit a board motion at this time.
Okay, those cases have been moved to the consent agenda properly. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion about the consent agenda? Seeing none, all those in favor of the consent agenda signify by saying aye. Aye. Opposed? Passes unanimously.
All right, for those cases that were just approved on consent agenda, you're done. You have the approval that you sought. Although you are welcome to stay, you're certainly not required to do so. So again, that's cases 2017-399, 2017-422, and 2018-011. Those cases have been approved. Please see the Codes Department no earlier than tomorrow so that they'll have time to enter the information and be in a position to help you with your permit. Mr. Chairman, as you know, here at the outset of the meeting, we also like to recognize our elected officials who are present with us. I know the first I saw today was Councilmember Tanaka Vercher. Councilmember Vercher, did you wish to address the board here at the outset of the meeting? Great.
My name is Councilwoman Tanaka Vercher. I represent District 28 out in Antioch, Southeast Davidson County. Good afternoon, Commissioners. Thank you for your service to this great city that we all love and greatly serve with humility and pride. I'm here to speak on case 2017-270, which is in Council District 32. The address is 3501 Murfreesboro Road. And I apologize that I was not able to be here when this was heard before commissioners previously. But I will explain my absence in that I would not have thought that my presence or anyone's presence would have been required due to that this particular section of our corridor is within a UDO. And I won't belabor the point. Many of you are aware of what the intent of a UDO and the process of that, where it requires various meetings with various stakeholders, council members, neighbors, and what it does, it brings a commonality and a spirit to various communities. And although I wasn't not elected at this time for this UDO, I have implemented several within my own respective district. You do know that it was adopted simply for adherence to protect the property owners by ensuring that adjacent properties develop contextually. It provides protection and assurances, not only just for current business owners and property owners and neighbors and neighborhoods and so forth, but also for future development that will be interested in coming towards developing on this corridor. Now, I know you're a technical body, and that's not your charge, but I just wanted to frame it for you that that's what this UD is and the intent of it. Now, let's speak to the matter of the request for the variance as it relates to the property at 3501. Murfreesboro Road, excuse me. I ask that you deny this variance simply because it's either a mobile detail or it's either a car wash. And you've heard arguments before as to what it is and what it is not. I will argue that it is a car wash. Therefore, the property owner or the businessman who's ever leasing it needs to comply with the standards set forth with the community intent as it relates to the UDO. As a body, you are charged with making sure that there's no ambiguity as it relates to the implementation and policies that's set forth in Title 17. An approval of the variance will exacerbate the public confidence that's already out there as it relates to our zoning policies. I ask that you deny this variance. We don't have an issue with the business being there, but if they're going to be there, they need to comply with the spirit of the neighborhood and the spirit of the zoning that we currently have on the books. And for that, I ask you again to deny this variance, and thank you so much, Commissioners.
Any questions for the council lady?
I have a question. So you're finding that it's acceptable that a car wash be there, but
The zoning will permit a car wash.
but you're asking that they build a structure.
Yes, and comply with the UDO. That's the current law that we have on the books. That's what the current zoning stipulates for the use for that property, not arguing the use or the zoning for the property. The UDO is currently there, and Council Lady Dow won't be here when she speaks, but I believe the UDO was in place prior to the use being in what it's actually doing. So there was no malicious intent as it relates to the council member or the neighbors or anything like that. When we set forth these standards, we do it with the spirit of enhancing our neighborhoods, with the spirit of enhancing economic development to our communities. One last point, because your question made me think of this. This would set a precedent. If we're going to start allowing variances for our zoning, for our overlays, where does it end? I mean, I don't have the answer to that. That's why I'm asking you to deny the variance. He should be made, he should comply with the UDO in accordance with anyone else, any other business that would come and set up shop on that corridor. We're not asking them to do anything that any other business would not be required to do within, as it relates with the current UDO that's currently on the books that was adopted.
Any other questions for Council Lady Vercher?
Well, just a comment. It did go to the Planning Commission, and for some reason they kicked it to us, and I don't recall that reason why they kicked it to us. I don't know if anyone else.
Yeah, the logistics and the merits of that, I'm not aware of why. I'm just here speaking to you as the technical body as it relates to trying to resolve the ambiguity in our Title 17 code, and that's your charge. That's why I'm asking you to deny the variance, because you're going to create a precedent here where variances can just overshadow overlays, and that's not the intent and the spirit of our zoning code. Now, is there small minor technicalities here? Yes, but we'll have to get ahead of that at another juncture. This isn't the case to do that. I know many of you have heard many arguments as it relates to Airbnb and the rules and the changes and so forth as to that. I ask that you don't open up that box in this case, requiring them to adhere to the UDO.
Any other questions? Thank you.
Thank you so much.
Mr. Chairman, we're also joined by the district council member for the subject case that was just discussed, Councilmember Jacobia Dow. Councilmember Dow, did you wish to address the board here at the outset or wait until the motion for a hearing is called? Very well. Wait until. With that, we've heard from the council members who are present at this time. I don't see any other elected officials in the audience. Boy, apologies if I missed one, because I just put my foot in my mouth if I did. With that, Mr. Chairman, you may recall that we had a case at our last board meeting. That was the February 1st board meeting, namely case 2017-445 involving the property located at 992 Barnes Road. The case was a request for a variance from the sidewalk requirements and a request for permission to pay into the sidewalk fund or the in lieu fund. Because we did not achieve 4 votes for any of the motions that were brought that day, the matter stays open for 30 days. So today, one of the board members who is absent from our last board meeting is in fact present. So Ms. Karpanek, I'll ask you, have you had a chance to review the entire case file for case number 2017-445?
Yes.
And have you also had a chance to review the entire video and audio recording of the hearing?
Yes.
Are you prepared to participate in a vote on that case today?
Yes.
Very well. Mr. Chairman, with that, because one board member is now allowed to participate who was not present originally, and because board members are technically allowed to change whatever their original vote was, we would solicit a new motion and a carefully recorded vote for today's vote on case number 445.
Okay. So please explain to the audience what we're doing and, who's here. And
The reminder, of course, is that this is merely a vote on the case that was previously heard. The board heard the case, closed the public hearing, deliberated, but failed to get the 4 votes. So as announced in my original description of the rules, the case stays open until we get 4 votes, or if there are no 4 votes in support of any motion at the end of a 30-day window, the case is deemed denied by operation of law. We are joined today by a number of the members of the community and the neighborhood nearby this subject property along Barnes Road. There are a number of residential properties there. Mr. Chairman, I know you sometimes like to seek recognition of those folks.
Yes, I do.
Allow you to do so.
Okay. So those who are in, opposition of this, please raise your hand. Okay. Brought a lot of people today. And those who are in support, please raise your hand. Okay. So John Michael.
So, Mr. Chairman, the proceedings today are merely to take a vote. You may recall, of course, this is a straightforward request for a variance from the sidewalk requirements, with the appellant having made the request to make a payment into the in lieu fund rather than constructing the sidewalk for the duration of the property at issue. Toward that end, we would solicit a board motion and a subsequent vote.
Okay. There you have it. Is there a motion based on the previously discussed case?
I move that we revote.
Okay. A motion, we're here to revote, so what is your motion about this particular case?
My motion is that we can solicit a revote on this case to
Okay. Yep.
establish.
That's what we're going to do. So, does anyone have a motion one way or the other on this?
I'd like to renew, if I can do that, the motion that I made last time initially was that we grant the requested variance and allow the building.
And allow them to pay into,
And to pay into the in lieu fund as suggested.
okay? Motion's been made. Is there a second? I will second the motion. Motion's been made and properly seconded. Any discussion?
How about dedicating the right-of-way as the planning department recommended?
I'm agreeable to that.
Okay.
I would amend the motion to include dedication of the right-of-way.
Okay, that's acceptable too. Motion's been updated, made, and properly seconded with the right-of-way amendment. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye, raise hands. Opposed?
Aye.
And,
I'm going to change my vote.
okay, so do you vote yay or nay for this? Are you voting in?
I forgot what I voted last time.
Okay, but what are you voting this time? Are you voting in favor of them allowing to put the money into the sidewalk fund?
Yes.
Okay, so to be clear.
Mr.
with
Chairman,
that-
if we could solicit a clean vote on that, just to be clear for the
Okay,
record.
those in favor of the motion signify by saying aye. Aye. Opposed?
Aye.
Okay, passes 4-1.
With that, the motion passes. We'll be prepared for our first case from the regularly scheduled docket, Mr. Chairman. Mr. Chairman, the first case that's on today is case number 2017-327. We'll pause for only a moment as some people choose to exit the meeting room. And And we would respectfully ask if the audience could do so quietly, as the board has hours of business in front of them that they need to start. Mr. Chairman, as you'll recall, case number 2017-327 involves a property at 446 37th Avenue North, shown here on the zoning map, just where 37th stops before falling off into I-440. Aerial photograph shows some of the subject property there. This was a case that has been called multiple times, and our appellants were not present at the last hearing. I'll go ahead and dispense with much of the calling of the case and just call for the appellant. Is the appellant, Mr. Steve Hatcher or Rajesh Nair, the owner of the property, present? With no one answering that call, Mr. Chairman, staff would recommend a motion to dismiss in accordance with board rules and with the ordinance.
Okay, so this is the second time we've called this case, and no one has shown up for it, so what is the will of the board?
I move we dismiss it. We heard this case. I think he was going to consult with some other people. This is the second time he's not attended. He can reapply. I'm going to move we dismiss.
Okay, motion's been made to dismiss. Is there a second?
I second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion to dismiss signify by saying aye. Aye, opposed, passes unanimously. John Michael.
The next case for the board's consideration is case 2018-001. Michael and Lori Shawn, the appellants and owners of the property at 859 Highland Crest Drive, have filed their item A appeal for a matter involving a short-term rental permit that was revoked by Code's zoning department staff. The property shown here on the zoning map and here on the aerial photograph had a short-term rental permit, received 3 strikes, and was revoked accordingly. The appellants are represented by counsel, Mr. Holland, who will take up the matter with the board. Is there anyone here in opposition to case number 001 involving the property at 859 Highland Crest Drive? Seeing none, the appellants will have 5 minutes to make the desired presentation. Mr. Holland.
Thank you, Mr. Chairman and members. Jamie Holland on behalf of Lori and Michael Chan. 859, that's okay, John Michael. 859 Highland Crest Drive. I want to first give her some time to offer some testimony, allow for some questions, and then at the end, very quickly, go over some legal matters for the purposes of the record. If you would, go ahead.
I'm Laurie Chan.
Please press your button and your name and address for the record.
I'm Laurie Chan. I live at 111 West Hampton Place, 37205. My husband and I bought this property in October 2015 for the purpose of using as a short-term vacation rental. The reason we chose this house was lack of proximity to downtown, knowing that nobody who was coming to town it would just be a different sort of clientele we would be serving at the house. I have lived within 5 miles of this house for approximately 40 years. I currently live 5 miles from the house now. The house to the left that you can see up there, Mike and Suzanne Sutton live there. I've known them for 20 years. The people to the right in the White House, the Warners, I went to St. Henry School, which is located less than a mile away with their children, 1st through 8th grade. I have only had the most wonderful people stay at this house over the last year and a half. I would say most people going on vacation are like all of us. They're pretty just normal people. I serve on the Wedding Guild at St. Henry Church, which is less than a mile from the house, and I have a lot of people that come to town for weddings and events at St. Henry's that enjoy the house for that purpose. I've never had a complaint from any of my neighbors. I have letters of support from my neighbors on both sides and from directly across the street. I respectfully and humbly ask for your support today. Thank you.
Mr. Chairman and members, the principal argument here is about the third strike, if you will, that was issued creating the case. And it was for advertising over the occupancy limit of 12. And at no time has there ever been more than 12 people in the house. There was a listing, if you will, on what I call a tertiary website called Flipkey, the principal ones being Airbnb and HomeAway. And it said in the listing that it could sleep 12, but occupancy is sleep 15, but occupancy is limited to 12. And I think that's the basis for the citation. And also, when to the consumer who might, want to stay at this property, if they were looking on the website, it's one of the first steps you take is how many people are going to stay there. So if you want a 10-person, 8-person, 6-person, and so forth, at no point in time was the property listed beyond 12, which is the maximum occupancy. So if you were seeking a place to stay with more than 12, this property would never appear on any website. And pending your questions and some comments from Mr. Osborne, that would conclude us for this moment.
What were the other 2 strikes?
According to what I have, Mr. Chairman, is there was one in August, again, for over occupancy, but it's like a repeat of the same problem.
Over occupancy or advertising over occupancy?
Yeah, I treat those as the same, correct, the same matter. But at no point in time has a consumer been allowed to see that property on any listing above the maximum.
So what was the second strike?
I don't want to interrupt.
Oh, go ahead.
I apologize. This most recent violation was on Flipkey, which I have the house listed on 3 platforms: HomeAway/VRBO, Airbnb, and Flipkey. I actually have records of all of the reservations on each site. I do 99% of my booking on VRBO HomeAway, so it's definitely a platform that I monitor more closely. On Flipkey, I have had between January of 2016, when the house was first listed, and December 18th of 2017, when I delisted, 3 groups stay in the house. There was a sentence on that Flipkey ad, which is my 3rd strike, that said, though the house can sleep up to 15 people, Metro Codes limits occupancy to 12. On that listing website, just one moment, there's a tab where you put your maximum occupancy, so that's what you're advertising, how many people you can sleep, and that was listed as 12 people.
So who wrote that sentence?
I did. And I don't know why it was in that ad and not in my other 2 ads. The only thing I can say is it's just not a site where I do a lot of booking, and it wasn't one that I monitored more closely. And that is absolutely my mistake.
Okay.
I mean, it's...
First strike and second strike, what were they?
I don't even,
She wasn't aware of them, Mr. Chairman. And
Okay, well, we'll hear from Mr. Osborne.
yeah, I got them at the last minute.
Okay. Questions for the applicant? Okay.
And do I get, after Mr. Osborne speaks, can I put some things into the record, or you want me to do that now?
Mr. Osborne, please come forward, first of many times today. Tell us about this property, any violations, and the other strikes.
Okay.
Because we have 3 strikes apparently. And
Right. The first strike was on April 14th of 2017 for not having the permit information in the advertisement and for advertising over occupancy. They were advertising for 15 people.
And what site was that? Do you even know? Or was that
On VRBO.
VRBO was on? Okay.
Yes, sir.
Second strike.
That was on 8/14/2017. Again, for excess occupancy. And this one was on HomeAway.
Okay. Just
Again,
advertising.
Advertising for 15.
Okay.
And then I believe there was a review from July 27th, 2017. The house is huge and was so beautifully decorated. Our group of 15 girls had more than enough room. And
So-
then
Last strike.
the last one was on December 4th, where in their advertisement, they listed that they could sleep up to 15 guests, but Metro Codes does not allow them to sleep more than 12.
So you did have 15 people, 15 girls apparently.
but I was not aware that there were 15 girls in that house. I mean, what I want to say is
Wait a
that...
minute. If you advertise for 15 and get 15, That happens, right? And that's why we have rules.
Absolutely. And I guess I'm going back to this most recent violation. And I mean, I'll accept responsibility for the previous two, but I can say that since that August violation, I have not had more than 12 people in that house, and I can say it without hesitation.
But isn't this kind of a nuanced response that basically you say, okay, it'll seat 15 or it'll hold 15, but the code only allows 12? Why'd you even say that?
I know, I absolutely understand that, and I'm sure that sentence had been in my VRBO ad as well, and I had taken it out, and I had a major mistake in not taking that sentence out of a flip key ad.
I wouldn't have felt as strongly about that sentence had it not been for what Mr. Osborne just said, that you rented for 15 people.
I understand, but you have to, it's hard to understand if you don't list a home on one of these sites. In that flip key listing, when you're listing a home, there's a maximum occupancy tab, and that tab was set for 12 people. So anyone looking to sleep more than 12 people my house would not come up.
But why did you write that sentence?
I just wasn't smart.
Okay. Questions for the applicant? Did anyone have any questions for Mr. Osborne? I don't think he got out of town for that. Okay, Mr. Holland, Counselor, close out.
We've also presented you with some letters of support from the neighbors on either side and across the street. It's important to note that the permit in question was issued on December 22nd, 2016. And the importance of that date is that the issuance came under the short-term rental law as it existed under BL 2014-951, which became effective July 1, 2015. All these ordinances cited in question, the application of the law here, did not become law until February 21, 2017, under BL 2016-492. So these citations represent a regulatory regime that did not exist under the issuance of this permit. So under Metro Code Law 1716-650, non-conforming uses, it says continuing a legal non-conforming use, period. A non-conforming use may continue. It does mention certain conditions to that, none of which apply here. So the fact that 492 was passed after the issuance of this permit, while it was still under its one-year period, I would submit doesn't have any application to the facts of this case.
Any other questions for the applicant? Okay, anything else to add?
I could not overstate my emotional attachment to this house. I am at this house 4 to 5 times a week. My son goes to school less than a mile from it, and I know the neighbors on either side of me so well. I'm sorry. I would never, ever have anyone in that house. The quality of people that have stayed in that house over the last year and a half would never cause disturbance to anyone. I'm always the first person there. I don't clean the house, but I'm always there immediately after people check out to make sure, the house is secured. So I would never, this is my side hustle. This is not.
What quality of people are you talking about that you wouldn't rent the house to?
Anyone here I have never had any bachelors in there. I actually, on one open weekend in June of 2016, I had one open weekend in June, and I got a call at 7 o'clock in the morning. This is unbelievable, from a group of 18 bachelors coming to town. They were doctors, and they offered me $4,000 in cash to stay in that house for a weekend because their East Nashville rental had water damage from a storm. I have 3 kids in private school. It is very, very, very hard to say no to any amount of money, but much less $4,000 cash in your pocket. And I said no. I know Mike and Suzanne that live right next door. My husband has worked with Mike for 17 years. I would never, I know I sound like some sort of horrible person. I'm just like this stay-at-home mom to 3 kids. I would never have anyone in that house that's going to disturb anyone. I have mostly people for weddings, family reunions, girls' weekends.
So the 15 girls, were they bachelorettes?
I believe they were, yes.
So bachelor parties, no bachelorettes? Okay.
No bachelors, absolutely not.
No
And I know that's technically probably against the law, but I would never allow a group of bachelors in that house. No way.
Okay.
My last guest that I had before I had to shut the house down in December was actually here from St. Ynez, California, escaping the wildfires. And she was there for 2 weeks from November 27th through December the 12th. I had a person stay in the house once who was adopting a baby. She was there for a month. She was here it was surrogacy, and they were here for a month staying in the house.
Okay.
And so it's just, because it's 30 minutes from downtown, it's just not a house where, I mean, the way I see it, I have these letters of support from my neighbors. You know, this is not the bad guy house out there that's ruining the quality of a neighborhood.
Okay. Thank you. We're going to
I
close.
appreciate your time.
Yes, we're going to close the public hearing. I want to ask John Michael, explain to us the 3 strikes and what we're here to rule on today based on what's in front of us.
So permits that are revoked because of 3 confirmed violations in a 12-month window, that's something that is sent to the zoning administrator, and he and I review, and if we find that, yes, there were in fact 3 violations, and that is not just a complaint, but a complaint reviewed by the codes department's property standards staff and confirmed as violations, then that gives rise to a revocation. That has consistently been the practice of the zoning division of the codes department since the implementation of that 3 strikes rule. So in that situation, an appeal to the board is an appeal challenging the revocation itself. It can be to the propriety of the revocation in sum, or it can be merely a challenge to one of the violations that was found by the codes department. If, in fact, one of the violations is determined by the board to not, in fact, be a violation, then there would, under this regulatory scheme, be only 2 strikes, and that would not give rise to revocation. So determining that one of the violations wasn't is, in effect, restoring the permit that had been previously and legally issued. Determining that all 3 of the strikes are, in fact, valid, and finding no other basis by which the board should overturn the revocation that was carried out by the zoning division of the codes department is leaving the revocation in place, obviously, and the former permittee would then have to wait 1 year until applying once again for a short-term rental permit. The question before the board then is, did the zoning staff err or act arbitrarily in issuing the revocation? If no, then it's just a yes-no question, because if no, then the revocation stands. If yes, we would humbly solicit the board's specificity with regard to which individual violation you deem not valid or whatever other basis, so that we can correctly identify that in the order.
Okay, board members, there you go. Discussion.
Well, I'd like to ask our lawyer about Mr. Holland's argument that because this permit issued prior to this 3-strike law, does that have an effect on what we're hearing today?
I don't think that if the permit was issued in 2016, the permit would be grandfathered until the expiration date, so the permit would still be valid. But if we change the regulations, I don't think the regulation, you're not vested in those, I don't believe you're vested in those particular regulations. Particularly something like this, I think would probably go to our police powers, and those are specifically not something that can be that are bound by grandfathering. So I think that yes, I mean the permit itself would be, you know, if the law changed with respect to whether or not you could have a permit, yes, you could maintain your permit until it expires, if that law changes. But with respect to specific regulations and strikes and within the law, I don't think that they are vested in that, and so therefore I don't think that they are bound. You are bound by the previous law.
Okay, discussion. So, as you know, it's a violation to list more than 12 people. And according to Mr. Osborne, on 3 separate occasions, they did. And on one occasion, they actually had 15 people. So it's up to us to determine, A, was the zoning administrator correct in revoking this permit? And if he was not, which of those strikes was he incorrect in? You know, the legislative body, the council, passed the law capping these at 12. You know, we had 3 separate instances here of just based on the record, it was. So the question is the third strike, which we're really also talking about, and it's kind of nuanced, if you will, saying the capacity is 15, but Metro only allows 12. So why would you say that, and does that fall under the law 12?
I personally don't feel like the administrator erred.
Does anyone have a motion?
I don't have a motion, but I would just say at this time, but I would say in contributing to people's thoughts, I'm troubled when we do have people that get their permits lawfully and are operating under a lawful permit, and then they have 3 strikes such as this, which I think is, which in general is problematic. In this case, given the support she has from the neighbors, it doesn't seem to be. So I just, I always struggle with the people that were already operating lawfully. I don't like to be in a situation where they're treated more harshly than people that come before us that have not been operating lawfully. So I just,
So this
I'm
is
thinking through
about,
that.
they had a permit lawfully, and because they advertised 2 separate occasions for 15 people, and one occasion they actually had 15 people, the permit was revoked. So we have to determine if that's correct or not.
It is troubling. I think it's a mistake that they had 15 people when they were not allowed to. Of course, to me, that's the one strike. I know how the law is written, that you can't advertise to have more, and they did that, and it was a very strange statement to make. But they acknowledge that you can only have 12. So I'm also feeling that to revoke or to keep the permit revoked is a very harsh penalty for something that seems more like a stupid mistake. But I don't know.
Was it a mistake, or was it somebody, because I might feel more that way, but previously Mr. Osborne said they did rent to 15 people.
Well, to me, then that's a strike. That's one strike.
No, but it's like, you know, they're saying, oh, this third strike is kind of fuzzy because we really said 12, even though we said 15, but they actually have written at 15 before. If there was no evidence in the record of them ever renting to more than 12, I think it's a little different.
Well, the appellant did say that she didn't realize there were 15 people there. She didn't go there and count them. But I wonder, and I wish I'd asked, did she receive money for 15? Because I'm sure they pay per person. I wish I'd asked that question at the time.
You can still ask.
I'd
Open the
like to
public
ask
hearing.
that question.
They don't pay per person. Mine is just a set fee per night, and I have electronic locks, so I'm not there, counting. I have no.
Thank you.
Whether there's 1 person or 12 person, how much did you charge?
It's $5.45 a night on a weekend and $3.95 during the week.
Okay, thank you. Close the public hearing again. Does that change your mind or give you more insight?
Well, I don't have as much to go on. So this is really a tough one. I agree with Ms. Chappell. You don't want to punish somebody whose neighbors are saying they've caused no problem as harshly as you would some of these that we've heard that have caused hideous problems in their neighborhoods.
Council passed these laws. And
Yes.
it says 12 people. And we have evidence of 3 times twice advertising more than, 15, and then once renting to 15.
Well, the city passed a law that I'm supposed to drive 30 miles an hour in my community too, and sometimes I go faster than that.
Yes, we do.
And so I have to think about relativity is what I think Ms. Chappell is saying and what I
Okay,
feel.
so the way that our oversight or appellate site is working here, we don't really get to do a lot, I guess, for relatively outside of how you vote. We either have to uphold the zoning administrator or not. So that's what we're here for.
Well, despite the fact that I may be working with an admitted lawbreaker, Ms. Sanford, and I would advise you not to say anything else.
Good criminal lawyer there.
The other thing that bothers me is if you get a permit 1 year and there's not 3, I bought a permit that doesn't have 3 strikes attached to it. And then the law changes, and now all of a sudden my permit has different requirements to it. And legal counsel has told us that the Metro can do that or the government can do that. That makes sense to me. At the same time, because we have that factor and because I'm not comfortable with the more harsh treatment for the reasons I've discussed, I would make a motion that we reinstate this permit.
Okay, and the zoning administrator erred, is that what you're saying? You have to find the zoning administrator
I would
erred.
find that.
And how did he err?
That it was arbitrary in finding that there was a strike that the house could sleep up to 15, even when it stated that the maximum occupancy was also 12.
Okay.
And I would second that.
Motion's been made and properly seconded. Any more discussion? Seeing none. All those in favor of the motion signify by saying aye. Hands opposed? Passes.
The next case for the board's consideration is 2018-002. Kathy Derryberry is the appellant and owner of the property located at 1208 Curry Road. This is an item A appeal regarding the revocation of a short-term rental permit. Zoning map shows the subject property here near the intersection of McGavick Pike, and then the aerial of the subject property, and from the assessor's website, the face of the property. Ms. Derryberry is also represented by, or the Derryberrys are also represented by counsel, Mr. Holland. Is there anyone here in opposition to case number 2018-002? There is. As a result, the appellants will have 10 minutes to make the desired presentation. After their initial presentation, the opponents will have the opportunity to address the board and have 10 minutes shared to do so. After that, if the appellants wish to save some time for rebuttal purposes, that'll come out of this originally allocated 10 minutes. With that, and excusing the formalities, if everyone would please reintroduce yourself by name and address for the appellants, make the desired presentation to the board. After their presentation, we will hear from the opponents.
Mr. Chairman, Jamie Holland for the appellants in case number 2018-002, 1208 Curry Road, and also the succeeding case, 2018-003. And I would ask the chairman if we could do those possibly in reverse order. This is Mr. Derryberry, who is the property owner of 2610 Couchville Pike. And the reason I ask, Mr. Chairman, is because the owner of 1208 Curry Road is in the hospital with her husband, who is very, very ill. And so if we could take that case and maybe he could give some insight in whether the decision, whether you want to defer it or go ahead and let
John
it be
Michael,
heard.
What do you think of that?
Yeah, no, procedurally, the board can take cases out of order. That's the first point. As to the second matter, with regard to a named appellant not being present, the appellant is in fact represented by counsel who is more than able to make a presentation on behalf of the named appellant, so that's not a problem. Taking testimony from whomever is a knowledgeable party on the subject is also just fine. So really, I didn't hear any problems in that procedurally with regard to the case. If the board chooses to take those two cases out of order, I don't think that's problematic. I can blow through the brief presentation to bring the board up to speed, and you can do that if you move and choose to do so.
Okay, board members, would you like to take case 003 first? Okay, let's hear them. Let's do it.
With that, just the overview is case number 003, as referenced by Mr. Holland, is for the property at 2610 Couchville Pike, shown here on the zoning map. This is also an item A appeal of a revocation of a short-term rental permit. As previously described, Mr. Joseph Derryberry is the named appellant and the former permittee on that subject property. Face of the subject property there. Mr. Holland represents both individuals, so in whichever order, the board can take up cases number 3 and number 2. Naturally, we will solicit separate motions and votes on those cases when the time is right.
Thank you, Mr. Chairman. This is Joseph West Derryberry. He's the owner of the property located at 2610 Couchville Pike, and my name is Jamie Holland, his attorney. And I want, much like the last case, going to let him introduce himself while he's in this predicament, and then talk to you some more. Thank you.
Good afternoon, honorable board members. My name is Joseph Derryberry. I live at 2610 Couchville Pike, Nashville, Tennessee, 37217. I'm a bit nervous, so I hope you'll forgive me for that. And my mother couldn't be here today. My dad's been he's been in the hospital for a little while, not heart trouble and breathing problems. Long story short, I didn't know I was supposed to get a permit, and when I found out that I was supposed to, I went and I got one. Thank you very much for your time. If there's anything
So
else.
why didn't you, so you just started listing this and renting?
Yes, sir. It's really easy to do that on.
Okay. So how did you find out that there were laws and you had to get a permit?
Just through family and friends, basically.
It wasn't a letter from Mr. Osborne or anybody else?
No, sir. At my residence, I didn't get a letter.
Okay.
That I can, no, sir.
Mr. Holland,
Is this I thought it was a revocation. But he does say that.
And for the benefit of the board, staff would note the revocation letter, I believe, is in Mr. Holland's documents also in this case, was a November 2017 letter under my signature from the Metro Codes Department. So if that answers the question that was in play, that it is a revocation.
they had a permit and then it got revoked?
That's correct. They have properly obtained a permit. However, staff missed the fact that there had been prior operation before we issued the permit. So when that was brought to our attention, we received documentation to that effect. That yielded the revocation. Of note for the board, looking forward and bearing any outcome with regard to this case, there are a number of those scenarios that Host Compliance is now bringing to us where they have identified prior operation that we on a staff level missed, thus yielding revocations where people had otherwise properly obtained their permits and had, as I think is the case in this instance, and Mr. Holland will probably speak to this point, no problems in the field, no records of violations, bad actor type stuff, just that there was the prior operation that we missed at the staff level because of our technological limitations.
So we're hearing but they were permits that were improperly issued because of the, okay.
Okay, Mr. Holland.
Thank you, Mr. Chairman. And I noted for the record, I talked to the two folks behind, and they're here on case 2, not on case 3. But this, the facts and laws are a little bit similar in this one, except the permit at issue here was issued prior to what I call the crazy date of October 28, 2016. And October 28, 2016 is when 8th Circuit Judge Jones issued an order concluding that the definition of short-term rental is unconstitutionally vague because a person of average intelligence would not be able to understand the differences and/or distinctions between short-term rentals and hotels, bed and breakfasts, and boarding houses, end quote. Consequently, in my opinion, on the date of the entry of that order, the city of Nashville had no effective short-term rental regulations. And that's
Mr. Holland, we've been through this before. If you're coming to this board and basically saying that the city didn't have authority to regulate short-term rentals, or we don't have authority to oversee them, that's just not going anywhere.
you stole my thunder there in the sense that I'm saying we reverted to a time period when the zoning administrator issued an opinion letter in 2014. I'm not saying nobody had the authority to do anything. I'm saying that the zoning administrator took the position, which has subsequently been affirmed in under oath responses to interrogatories in the Anderson v. Metro case that just issued an opinion of the Court of Appeals on January 23rd, 2018, that instead, there wasn't anything to violate. It was permitted as an accessory use. I'm not suggesting you didn't have authority to do it. It was just the position of the department. It was permitted as an accessory use.
Okay, so let's just back this up. Why are we here? We're here because your client got a permit, and then they found out he had rented before he was issued the permit. So please make your argument based on why his permit should not have been revoked based on his activity.
Well, Mr. Chairman, sorry, but I had to get those in for the purposes of the record.
And we have your full order that you submitted to us from the 8th Circuit. Yes.
Great. So I think to ordinary people, when that opinion was published in the news media and what have you, there was a period of time where nobody knew what the laws were, and that if you needed a permit, and when he found out that he needed a permit, he came and got the permit.
I seem to remember, Mr. Holland, that there were some articles in the newspaper that did cover this case, but I don't remember any local press saying just because this ruling was what happened, that we have no laws related to short-term rentals. Do you have such an article that you can show us today?
I would like to move I'd like to move my case down a few positions in order to present that to you if that's going to be outcome determinative, yes.
So you can find an article from either the Tennessean,
that's the one.
Journal, the Nashville Scene, that basically said, based on this ruling, that there's no oversight of Metro of short-term rentals. That's what the article's going to say?
That's the gist of the article. I don't know if that's going to say those words exactly as you recited them.
But it will just basically say, don't worry about rules and regulations because of short-term rentals, because a judge has basically said you don't have to.
I think
what I remember is what the media said, this one particular case with this one particular party might not have to worry about it, but everybody else does.
So on October 28, 2016, it was reported in the Tennessean, this quote, "The definition of short-term rental is unconstitutionally vague because a person of average intelligence would not be able to understand the differences and/or distinctions between short-term rentals and hotels and bed and breakfasts and boarding houses." End quote. That sentence was in the story. Now, that was October 28th.
That was quoted from the judicial ruling,
That's right.
But so what's important, Mr. Holland, before that is what it says. Does it say to the world and Nashvillians, don't worry about short-term rentals anymore because there's no authority? It didn't say that. It said the judge said that, but it didn't go on to say just because this one ruling for one party, everybody else that has a short-term rental doesn't have to worry.
Now, at the time that order was issued, it did not say this only applies to the Anderson.
I'm talking about the newspaper, which was your argument, that basically your client and everybody else in Nashville that had one of these didn't have to worry because this one ruling said for one party you didn't have to worry.
Well, the way you're framing it is that this case, this order only applied to that party, and that's not true. That was not true until Judge Jones revised his order in December of 2016, 6 to 8 weeks later. But otherwise, I think to folks of average intelligence, that when they when the judge says something's unconstitutionally vague, I think that means that the ordinance is unconstitutional.
May I say to Mr. Holland, do you have an idea of what date that was? I well remember reading those articles about Judge Kelvin Jones and what he said, and that he did revise his order. Have you a time frame between the first, and I don't know that the newspaper had everything 100% accurate, but I had read the first one that said what you read, and then another one that said, and I do read the Tennessean, and it did say that this applied only to this case. But was the time frame there? I think you said December was when he revised it, but when did he first issue that opinion?
The first issue, the first order was issued October 28, 2016.
Thank you.
Then the subsequent order was issued, I think it's December 22nd. I wouldn't swear to it. That's why I'd like to move down a few positions, if you would. Sometime in December of 2016, where the order was revised. And Metro filed a motion to stay the imposition of that October 28th order, and that motion was denied.
Okay, so Mr. Holland has asked to be moved down, and he's got another case where the client isn't here, so what does the board think about that request?
I move that we allow him to move down.
Okay, and during that period of time, you're going to find this Tennessean article that basically said, don't worry about short-term rentals, everybody else, because one judge has said it's invalid.
Well,
Just before we do that, I would like to make one point of clarification with respect to the Anderson case. Judge Jones issued his ruling. His order would not have been effective for 30 days. Within that 30-day period, Metro filed a motion to alter or amend that order. Our motion stayed his order until he ruled on our motion in December. So therefore, his order was not effective until he ruled on our motion to alter or amend. When he ruled on that in December, he specifically limited it to the defendants in that case. So there was never a time period where his order applied to Metro at large saying there aren't any regulations, because we filed a motion to alter or amend before the order was effective, and that stayed the order.
Okay, so we'll move down, we'll find an article, we'll come back. John Michael. Oh, we're going to have a short recess.
Economy. Perhaps we could call another case while we're waiting to reconvene on the two that were in play previously. Staff would humbly recommend pulling up case 2018-012. This is a case for Mr. Stephen Fry, and he is present. It involves the property at 3733 Baxter Avenue. It's a short-term rental case and technically an item A appeal challenging the zoning administrator's denial of a short-term rental permit. Staff has extensive information with regard to this unique case for the property located here on the zoning map and here on the aerial face of the property that's in question. I believe Mr. Osborne had this case in environmental court recently and will be able to speak to the matter. Mr. Fry is present, so if you will just introduce yourself by name and address and then take it up with the board.
Good afternoon. My name is Stephen Fry. I live at 3733 Baxter Avenue. I recently was seen over at environmental court, and my case was dismissed over there. The issue is that I had apparently not had a permit, but I've provided documentation to Mr. Osborne, and he understands my case more thoroughly. And essentially, I would like to get my permit capabilities reinstated right immediately. I was attempting to be compliant and did not mean to be so. I believe Mr. Osborne could speak to the logistics of my case more than I could.
Mr. Osborne, please come forward and tell us about this case and why it's here and what kind of conversations you've had about it.
Okay. This was one that we originally picked up with host compliance. And whenever the property was re-inspected to see if it came into compliance, it was still posted, so I issued a warrant.
What was the initial violation with host compliance?
Just not having a permit.
Okay.
Mr. Fry came to court and showed us documentation that he received a letter from, I believe, Finance. I believe he has a copy of it in his files that said, you need to pay your taxes, you have a short-term rental permit. So we were confused to see how he got a letter for having a permit when he did not have one, but it looked like he had applied for a permit previously, and that application was not finished.
Okay.
So that's why we dismissed that, because we could see the confusion.
Dismissed it in front of environmental court?
Yes, sir.
So now it's here?
Yes, sir.
So what other violations outside of having a permit have you found out?
None that I'm aware of.
Okay. Any questions for Mr. Osborne? Okay. So you're in the process of completing an application, and then you got this letter?
Sure. So I had done an application and was under the understanding that I had a permit because I had a letter with numbers at the top. And so.
What was missing in your application?
I'm not sure.
Did you have a fire marshal inspection of the house?
I believe that was the only item that was missing, yes.
Okay, well, you need that until you get, it's not complete until then, so what are you asking us today?
So based on, I'd like to not have to wait a year since I was found not guilty and the case was dismissed in environmental court. As I was under the understanding that I had a permit, I'd like to be compliant. And as a development differential person, I work from home, and so this is my means of income. And so I'm already living off of credit cards and savings to be compliant right now by not operating this business, and would like to operate this business in a compliant manner as soon as possible.
Okay. Any questions for the applicant? Thank you for being here.
I have a quick question. What's your dog's name? The dog's beautiful.
His name is Onyx.
Onyx, an ironic name. Okay, we're going to close the public hearing. Discussion or motion?
Well, if there's no discussion, I'll move that the zoning administrator did not err and that the applicant be able to apply for the permit tomorrow.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. So you are now eligible to apply for a permit. So make sure you have all the paperwork in and talk to the folks over there, and that's who you deal with. Thank you for being here. Thank you for bringing Onyx, and good luck.
Thank you.
Mr. Chairman, let's pick back up where we left off. I believe it was case 2018-003. Mr. Holland and his client, Mr. Derryberry, are still here. We'll pick back up where you left off on that one, having now resolved this last case.
Thank you, Mr. Chairman. Member, from the Tennessean dated October 21, 2016, headline, Nashville's Airbnb law unconstitutional. Author Stacy Barchinger and Joey Garrison, lead paragraph. A judge ruled Friday that Metro's ordinance regulating short-term rentals, such as Airbnbs, is vague and thus unconstitutional, delivering a blow to the city's attempt to manage the fast-growing alternative to hotels.
Keep reading.
The immediate impact of the ruling is unclear, as Metro lawyers say they will likely ask that it not go into effect pending appeal. Council members who supported the ordinance that lays out regulations for short-term rentals said they too are evaluating courses of action after the judge's ruling. Quote, we don't have a written order from the judge yet, so we haven't made a final determination regarding next steps, end quote, Metro Law Director John Cooper said. Quote, however, at this point, we envision seeking a stay of the ruling while we pursue an appeal. If a stay is granted, the ordinance would continue to be enforced as it is today, end quote. Cooper said and that stay, they made a motion for a stay. That stay was denied. Cooper said the judge's ruling is not final until a written order is entered. Airbnb hosts will still pay hotel taxes as required by a Tennessee Attorney General opinion last year, he said. The conservative think tank Beacon Center of Tennessee filed a lawsuit in August 2015 on behalf of Salemtown residents PJ and Rachel Anderson, arguing the ordinance infringed on their rights as homeowners. Lawyers gathered before Circuit Judge Kelvin Jones on Friday because Metro had asked the judge to end the case and grant what is called summary judgment, saying there is no merit to the claims in the lawsuit. The hearing lasted over 2 hours. Quote, the Andersons are delighted that they can start making life decisions based on what is good for them instead of being impacted by an ill-thought law, end quote, Braden Busek, Director of Litigation for the Beacon Center, said after the hearing. Jones agreed with Metro Attorney Catherine Pham that the ordinance's 3% cap per neighborhood on non-owner occupied short-term rentals did not violate equal protection laws. He said the law created a monopoly, but one that was permissible because it was for the well-being of citizens. But on the issue of vagueness, Jones said the law was unconstitutional. Busek had argued there was confusion between laws regulating short-term rentals and establishments such as hotels and boarding houses. He said there were conflicting definitions on the books about what is, quote, transient occupancy, end quote. When the Andersons received a letter asking them to pay hotel tax, they were confused. He said, quote, I admit this is an incoherent mess, end quote, Busek said in court. There was simply no way to make sense of this, and every Nashvilleian could find themselves in a bind where Metro can arbitrarily say you're a short-term rental one day and a hotel the next. Pham argued that because Airbnbs are in district zone residential, they cannot be commercial establishments such as hotels. She said the definition of hotel is different for zoning and tax purposes and that any person could read those distinctions. Jones did not agree. Quote, because the definition of short-term rental property is subject to multiple interpretations, the court finds that an ordinary person of average intelligence would not be able to understand the distinctions between short-term rentals, hotels, bed and breakfast, boarding houses, hostels, etc. End quote. Jones was elected 2 years ago and formerly worked in private practice as the executive director of the Metro Human Relations Commission. The Beacon Center said in a news release the lawsuit was the first of its kind in the nation and hailed the decision as a huge victory for homeowners in Nashville and across the state. Quote, not only does the ruling show that the Metro Council completely disregarded the state constitution when it passed this law, quote, the statement reads, quote, but it also sends a loud and clear message to cities across the state when it comes to restricting homeowners' rights in the new economy, end quote. The ruling marks a setback for a law the Metro Council passed in early 2015 that sought to regulate Airbnb and other short-term rentals, which have become increasingly popular in Nashville. The ordinance was conceived as a way to address concerns of residents who have complained of noise in large groups at Airbnb homes. The law requires that Airbnb hosts apply for city permits to operate and pay the same level of taxes in hotels and motels. So far, 2,262 people have received short-term rental permits in Nashville. It also mandates that hosts be at least 21 years of age, provide proof of liability insurance coverage, and has no more than 4 sleeping rooms. Under the law, stays of guests are limited to fewer than 30 days, and the number of guests to twice the number of sleeping rooms in a home plus 4. There are rules about noise, recreational vehicle parking, and the number of short-term rental permits allowed per census tract. At-large Councilman Bob Mendez, who has pushed for additional rules targeting Airbnb this past year, suggested the ruling could have major implications. Quote, if the thought is that the law regarding investor-owned short-term rentals is vague, that sort of pushes us toward having no regulations or outlawing them completely, end quote, Mendez said. We'll have to figure out what happens next. Councilwoman Berkeley Allen, the lead sponsor of the ordinance, said she was surprised and disappointed by the decision. Allen said she and other council members are waiting to learn more details to decide the next course of action. Quote, it's good to have short-term rentals in Nashville under reasonable guidelines, end quote. I thought we had reasonable guidelines. There's certainly plenty of neighbors who feel like it has the potential to have negative impacts on neighborhoods, and we'd like to control that. So I hope we'll find a way to do that while still allowing it to be a part of Nashville's hospitality scene. Sean Braystead, a spokesman for Mayor Megan Barry, said Metro attorneys are reviewing the decision and will advise the mayor and the council on the best course of action. Although Nashville's Airbnb rules have been in place a year and a half, Metro has struggled to enforce some of the regulations, particularly the cap on number of guests allowed at a home. Barry's administration this month hired an outside consultant to review operations of Metro Code's department in order to identify the type of staffing needed for enforcement. The consultant's work includes exploring whether the Codes Department, which is currently tasked with enforcement, is best suited for that responsibility. Barry nixed the possibility of Nashville police officers being tasked with the role of Airbnb patrol, which some council members have suggested. The end, Mr. Chairman. I apologize, I was not prepared to read that long.
That's a mighty long article for the Tennessean. Okay, so based on that, your client relied on that?
I think it's fair to say that everybody relied on that. That, for a period of time, we were in regulatory limbo. When he found out he needed the permit, that was an affirmative fact. He got the permit, and, there's been no complaints against the property since, from neighbors, noise, trash, debris, party house, any of those things. That hasn't been the case.
Okay.
Sir, if I may, I'm
Yes,
so
of
sorry to
course.
interrupt you. That went on longer than I anticipated.
Okay. Well, I asked for it, so it didn't count against your
I'd
time.
just like to say I am from Nashville. I was born and raised here. I'm from Donaldson. This home that I currently reside in, we got lovely wildlife and stuff out there. We're right near the lake. It's very beautiful and it's very quiet. And you're fairly close to the city. Just down from where I grew up. I also grew up just down the road from here. I apologize that I'm even here today. My goal here is to comply, and thank you very much.
How many times did you rent it?
I'm not sure offhand.
Is it 5? Is it 20? Is it 100?
It's maybe 20. Maybe.
Pre-permit or since he's had his permit?
Total.
I'm not really sure.
First of all, Mr. Holland, he wasn't given a permit correctly, as you know that.
I did receive a permit, sir. I'm sorry.
Incorrectly.
Okay.
Mr. Osborne, how many times was this property rented? Do you know? Through the magic of host compliance, we have a lengthy record, I'm sure.
Looks like about 50 times.
50 times, okay. And you sent him a letter when?
There was no letter issued on our side.
They just revoked a permit.
Yes, because we received an email from our director saying there's some address mismatches for owner-occupied permits. Looked into this particular property, found that it had reviews from prior to having a permit, so I referred that to zoning. There weren't any issues with the advertisement at that time. It was in compliance, so there was no need for an abate letter from my department.
Very good, thank you. Any other questions for the applicant? Anything else to add? Okay, we're going to close the public hearing.
Thank you, Mr. Chairman.
Discussion. So, despite what we were hearing earlier, this case is like many others. It comes down to somebody operated before they had a permit. You know, there's this fog of they were given a permit incorrectly and then it was revoked by Metro, but, you know, it just comes down to, oh, I didn't know that there were flaws, and now I want to be compliant, and he's rented 50 times, so there you have it.
But it's 50 times total, so we don't know. What I don't know is how long he had the permit before it was revoked. Do we know that information?
We have that information in your packet, Ms. Chappell. I believe that it was a single-digit number of rentals. I think from the host information, it looks like it was 4 confirmed or documented stays in July and August of 16. And it looks like the permit is a 2016 permit, specifically late September of 2016. So taking a look at the confirmed or documented stays based upon the host compliance data, call it 5 stays preceding the permit, the majority of them thereafter, and then the permit revocation date was November the 20th.
So you're saying about 40 or 45 of these were under the time he thought he had a legally binding permit?
That appears to be the case.
Okay.
And I didn't write this down, so I don't recall. Did the applicant find out through host compliance or came in on his own?
It seems that they came in on their own because I believe the coming in for the permit predated host compliance.
So they came in and got a permit, and then host compliance did its due and said, hey, they were operating before you gave them a permit, so you should take away their permit. So that's what happened.
Okay.
And as John Michael said, there's about 4 cases of renting the house before they had a permit. So based on that, and that's really the issue. So discussion.
I mean, I would still rationalize this the same way we do when people come in and we have the discretion to determine whether we're going to hold their ability to apply for a permit up to a year. I don't see that this case is different. I mean, I'm hopeful that we're going to have a batch of these where maybe they're improperly issued and revoked once host compliance then catches up. But I still think we would handle them the same way we would handle one that somebody came in trying to get into compliance. So I'm still a little fuzzy on the dates of it, but according to the letter, he has, I believe, he pulled the listings according to Mr. Holland's letter.
Right.
And based.
Let me ask our lawyer a question. So we're here to just kind of rule up or down whether the zoning administrator erred. We don't have any latitude to say you get your permit back in 2 months or 6 months or
Not
anything
with
like
this,
that.
because this is a revocation, the year, up to the year term does not apply.
So it's either yay or nay, and if it's yay, he gets the
Either it was-
permit back immediately, and if it's
Either it was
no,
properly
it's a year.
revoked, right, either it was properly revoked and the revocation will stand, or it was improperly revoked and they're eligible to, or I
Okay.
guess it would be reinstated.
Yes, okay.
And though in looking at that, I understand that's what we're dealing with, but in my mind, I would still analyze it in the same way, but getting to the result of, I mean, I would find that the zoning administrator acted arbitrarily, and therefore the permit should be reinstated.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Discussion. Seeing none. All those in favor signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Well, the band's all together, Mr. Chairman. Let's call 2018-002. That is the case involving Kathy Derryberry as the appellant, represented by Mr. Holland, previously shown here on the zoning map for that intersection at Curry Road, the aerial, and the face of the property. Having previously introduced himself, Mr. Holland can make the desired presentation on behalf of Ms. Derryberry, the property at 1208 Curry Road, in case number 2. As a reminder to the board, there are members of the public present in opposition to this case, so both parties will have 10 minutes to make their desired presentations.
Thank you, Mr. Chairman and members. I'm here on behalf of the appellant, Kathy Derryberry. And as I stated previously, despite all my urging, she could not be here. She's bedside at the hospital with her husband, who's been there for an extended period of time. The facts are much the same as the previous case. The difference would be the permit in this case, 1208 Curry Road, was issued October 6th. and the permit in the last case was issued September 29. And to not belabor the point and make the similar argument, same set of facts. As soon as she found out, she came down here, got the permit, did the process, whole deal, and I would yield the rest of the time to hear from the neighbors.
Any questions for the councilman? Okay. Opposition? Please come forward. Please state your name and address for the record, and why you're in opposition, of course.
My name is Terrence Heaney. I live at 1222, 4 houses away within 600 feet. My overriding concerns are if the dairy berries are going around the city creating Airbnbs, who's going to be monitoring the problems of beer cans, noise, particularly there's 2 homes directly behind here with a lot of children living there and their parents, 5 houses across the road, if you look at that map, all with children living there and their parents. And regardless of your argument on the issues you've approved, you do need to take an ethical look at the neighborhood. To quote the previous councilwoman, this does nothing to enhance the neighborhood. And you start with one, and then we're going to have the whole neighborhood wind up with these. The children is one of my major concerns, and being awakened and with no one to monitor what's going on. I'd like to go ahead and turn this over to Mrs. Curry, who's lived there for 69 years. Mrs. Curry, if you want to step forward, please.
Mrs. Curry, welcome. This is Curry Road, so I imagine the Curry family has lived there forever. So please state your name and your address.
Mr. Chairman, I'm Betty Curry. I live at 934 Curry Road, have been there for 69 years.
Why are you in opposition to this?
I'm in opposition, yes, opposition to this. Curry Road is a family-oriented neighborhood. There are a lot of families with children, small children. There are a lot of elderly people that live in that area. I can tell you because I've been there long enough to know. In renting out a residence for a night, a day, a week, or whatever, to me that is a commercial business. They are charging a fee for someone to stay there. It may not be zoned as commercial, but if you're charging a fee for someone to use your business or to stay in your home, to me that is commercial. How do we know what's going to go on? I live just right around the corner from that. My property runs from Curry Road to McGavock Pike. And I can go out my back door and get down to this in about 5 minutes. There are a lot of houses on Terra Ann Court right behind me that have children, small children. And I think of those children, and they are out all day and night. And if we have someone that is staying there that we do not know who they are, how will they be monitored to know what's going on in those houses, in that particular house? People that come in that spend a day or a night or a few days have no interest in the neighborhood. They don't take care of the property, I know for sure. I'm concerned with parties, with trash, with a lot of traffic going on during the night, at all times of the night. And I have great-grandchildren that just live around the corner from there. I don't want this in my neighborhood.
Have you witnessed any noise violations, parties, or any of the things you talked about?
I do behind me on Terra Ann Court.
I mean, with this house?
Well, no, I thought our councilman lady lived there, but I found out evidently not.
Okay.
It's been turned over to the family, and the family wants to rent it out in order to make money.
But
now, I don't know where she is.
About this particular address, have you ever seen anything happen like trash or noise or anything like that?
Well, not since she's been there, but she hasn't been there that long.
Okay.
this is a fair, I can't tell you exactly when she moved in, but I know the house looked like it's not unoccupied now. I don't see any coming and going, but it has been.
Okay.
I haven't seen that, but I know of others that where this happens, that there is a lot of uncertainty about what's going on.
There was in the past a lot of going and coming of cars a couple of years back, so I don't know how long they lived there, but there were issues.
Anything? Yes.
What are the rules for renting your house out? Now, I have the newspaper, Tennessean.
Tennessean's getting a lot of press today, by the way.
January the 24th, 2018, where it was voted down by council to phase out this Airbnb.
To phase out non-owner occupied, meaning if you didn't live there, they're not going to let you have those kind of permits. But if you live there, you can still have them.
How can you live there and rent in a house that small and rent out if you live there? That's my concern too.
Well, yes, that's what the council, you have the article in front of you, that's what the council did.
Well, right.
So this particular, so you're against this getting a permit because you just don't like Airbnbs, or what's the reason?
I'm against this because I see our neighborhood is going to turn into this, because where I live, there are a lot of the older houses, the people that lived in those that are selling their property and retiring or dying out. And my concern is if this starts right here, when is it going to end? Where will it end?
Any questions for the opposition? Do you have anything else to add?
No, I think it's been covered.
Okay, thank you. We're going to hear from the applicant again. Thank you for being here, Ms. Curry.
I will hold this chair, Steve.
Thanks.
Okay, Mr. Holland, your response.
Thank you, Mr. Chairman. With all due respect to them, I appreciate them coming down here to air their concerns, but I would categorize them as general grievance with the policy position, not having any evidence of any, the bad neighbor activity. And I would ask that, the permit be reinstated. They've been, as soon as they were told to get in compliance, they got into compliance, Mr. Chairman.
Mr. Osborne, tell us about this property. So how'd you hear about it, which I think I know the answer to that, and what kind of violations were there?
Well, again, I heard about this one from the director, which briefly looked into these after an email from the director.
The director?
Of codes. He had received
the director of codes, okay.
He had received a huge list of properties that had address mismatches, and this is one of the ones that
and so
didn't have any violations at the time, so no case was generated. It does look like back in August of 2016, Greg Stiles did issue an abate notice for operating a short-term rental without a permit, and it looks like they came into compliance on August 25th from his records.
How many times have they rented it out, and how far back does it go?
It goes back to May of 2016, and
when did they get a permit?
they got their permit on October 6th of 2016.
And how many times have they rented it before that?
At least 12.
And then after that, before they got their permit revoked?
Around 49 times.
Okay, but they thought they had a permit.
Right.
Any other noise complaints or non-permit violations?
No, sir.
Any questions for Mr. Osborne? Okay, nope, thank you. Mr. Holland?
No more comments, just pending your questions. Thank
Any
you.
other questions?
Is it type 2? or type 1?
Excuse me. I had to think after reading that long article from Tennessee, and my mouth is dry and my brain's not working. Non-owner occupied, right? For your mom's property.
I'm sorry, what now?
Your mom doesn't live at 12.
No, sir.
Thank you.
Any other questions?
Well, the neighbors seem to have concerns about who is in charge if your mother is not there. What is the situation? How is that set up?
My family lives just down the street from this house. It would be walking distance for me. It's probably about a mile, maybe if that. I actually do a lot of the lawn work there. And so as far as litter and stuff goes, that is not the case at this property. Like I said, they drive by it practically every single day. If you need me to answer that further.
Have a complaint, who do the neighbors call if there's an issue? If your mother doesn't live there, who's in charge?
I mean, I'm sorry, what exactly, like, how do they contact me?
Ms. Chappell, if I can help on this, because it's probably unfair to ask Mr. Derryberry to answer for the property that he's not directly involved with. The listed contact under the permit is, in fact, Ms. Kathy Derryberry, so she's the person who, in principle, if there were any issues, would be the appropriate person to contact, as listed in our records. Of note, it was actually applied for and received as a Type 1, or owner-occupied permit, when it was originally obtained.
So what are we ruling on today, a Type 1 or a Type 2?
Well, what's revoked is a Type 1.
A Type 1 is revoked.
Yeah, and Mr. Chairman, for what it's worth, it's not impossible that it was issued as a Type 1 in error. There was no representation made in terms of the addresses shown. Yes, I lived there. It was actually, I think, a Dunolly court address that was shown as Ms. Derryberry's proper address. So could have been issued that way in error, but that is, in fact, how it was issued.
But it's a Type 1 permit that we would be reinstating.
You would be reinstating a permit. I think a Type 2 would be subject to reinstatement, potentially, given the fact that it was issued and timely renewed before Council Bill number 608 was finalized, so it wouldn't be treated as a new permit. But that would be subject to review. If, in fact, it is not an owner-occupied property, it necessarily and by definition cannot be an owner-occupied permit.
Okay. Well, let's close the public hearing discussion.
This is really confusing. And we have testimony, no one is living there, and there was no denial of that.
So I think what John Michael just said after this, that basically we're still deciding whether to either keep the permit revoked or reinstate it. We don't have to determine
We don't have to
who
know
lived
which
there,
type.
what type, and all that. We're just trying to decide, did the zoning administrator err in revoking it? So that's what's in front of us.
And he did say 49 rentals after the revocation?
No, so after they got the permit, so they rented 12 times before they got the permit. They got a permit, and because of host compliance, going back and looking before you got the permit, they found out you rented 12 times before you got the permit, therefore we're taking away your permit. And that's what happened. So the 40-some times, they had a permit, or they thought they had a good permit, and so it's really the 12 that we would be kind of looking at. But this is just one of those cases where if this was someone who was trying to apply for a permit, we'd be trying to determine, should they get a year, should they get 6 months, should they get 3 months? But right now, all that's in front of us is saying, should they have their permit or not? Did the zoning administrator err or not? So if we say he didn't, then they don't have their permit. If we said he did err, they immediately get their permit. And staff gets to determine which kind. Any motions or discussion?
I'll make that I made on the other property, and thank you, Mr. Michael, for clearing up. I did have questions because I thought it was a Type 2 permit. I would make a motion that the zoning administrator acted arbitrarily and the permit should be reinstated.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion?
The only thing I want to point out is that the date of their application is December 19th, so they've basically been, I guess, penalized in that way. They have received a penalty. I know we can't judge on that, but I wanted to bring it up that there is some kind of penalty that they've suffered.
Okay. Motion's been made, properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael.
Mr. Chairman, the next case for the board's consideration is 2018-005. Don't mean to surprise you, but it's a short-term rental case. Matthew McCarty is the appellant and owner of the property located at 411 Rudolph Avenue in Council District Number 6. I believe you have an email in your case file from the district council member, Mr. Withers, regarding this case. The appeal is challenging a denial of a short-term rental permit. Mr. Rudolph is present. Very well. Is there anyone here in opposition to case number 005? Seeing no one, the appellant will have 10 minutes to make, or rather 5 minutes to make the desired presentation to the board. Please just introduce yourself by name and address, and we'll proceed.
Thank you, John Michael. Matthew McCarty, 411 Rudolph Avenue in East Nashville. Thanks to the board for your time today. So around November 6th of 2017, I received a notice from Metro Codes and Mr. Robert Osborne dated for October 27th, notifying me that my home was in violation as a short-term rental property. I began correspondence with Mr. Osborne on November 8th and spoke on the phone with him about the matter. My wife and I had been legally operating our short-term rental for a number of years in compliance with local laws and good standing with our neighbors, no complaints or strikes against us. I hesitate to involve the board more than necessary in my personal affairs, but the cancellation of this permit, which led to the violation of operating without a permit, is directly related to a pretty unexpected divorce in my marriage in the last year. So my now ex-wife canceled our STRP without my knowledge. So I was initially operating illegally while unaware that I was doing so. As y'all can imagine, this has been kind of a complicated time in my life. Mr. Osborne informed me that Codes had not seen a case similar to mine and that they might be able to simply reinstate my permit. After speaking with Clint Harper and John Michael, he said that wouldn't be possible. I would need to come in and apply for a new permit with Codes. To be frank, I was temporarily living in another state while divorce matters were complicated at home and before my wife moved out of our home. I also travel a good bit for my own work and was doing more than normal at the time to try to keep up with the financial obligations I was left to deal with our family. I attempted to get into the Codes office twice for appointments to reapply with no success. On the second time, I was told, hey, you should come before the building even opens if you want a shot at getting an appointment today. So the next time I was in town for a stretch, I did that. In the meantime, I actually received a notice from Codes in the mail that said I was eligible to renew my current permit and that it hadn't expired until December 15th. I have that notice, but obviously after talking to Mr. Osborne, I assumed that was just missed in the mail. When I was able to meet with someone in Codes on December 21st to reapply, I was told I would be denied for operating without a permit and that I would need to come before the board as my next step. I didn't really understand the process or what was happening, and it didn't really get explained to me, but the person I was working with assured me that an email I would receive would tell me next steps about this process. Sometime in January, I realized my name, property address, and email address were all taken down wrong on my appeals form, and that I was also not assigned a case number. So I corresponded with Ms. Debbie Lifsey at Codes. Eventually we spoke on the phone. She straightened things out for me, and that's how I'm before y'all today. I don't want to waste the board's time or Mr. Osborne's time, so I want to be frank in saying I'm aware that I operated without a permit after receiving his notice. I definitely did. I won't try to deny that. I did this a handful of times in an effort to try to make financial ends meet while I'm sorting through this. And Obviously the permit was canceled arbitrarily without my knowledge. At first it was maybe going to be reinstated, then it was going to be renewed, and I've just been trying to get into codes to get that done. I apologize to the board for my actions in renting it when it was not permitted. This has been a humbling experience during an already stressful time for myself and my family. I ask for the board's leniency under extenuating circumstances in allowing me to again apply for a new type 1 STR permit, since my previous permit was not allowed to be reinstated. As John Michael mentioned, you should have a letter in support from my council member, Brett Withers. Thank you for your time.
Okay, questions for the applicant? We're going to hear from Mr. Osborne. Mr. Osborne, please come forward, tell us about this case and any other non-permitted violations.
We found out about this one through host compliance. The usual bait notice went out. He contacted me, told me the circumstances, and I did check in with zoning to see if there was anything we could do, because I hadn't heard of this situation before. And unfortunately, he had to go back through the process. And even with, he would had to do that anyway because of the ownership change that would soon happen due to that situation. He did keep renting in December at least a couple of times. So that's about all I know about this one.
Okay. Questions for Mr. Osborne?
I can probably find this in the board packet, but so you're saying a letter went out at some point and...
Yes, the letter went out on October 27th, and he probably got it November 4th or 5th.
Okay. Anything else? Thank you, Mr. Osborne. Anything else to add?
No, thank you for your time, Mr. Chairman.
Okay. Any questions of the applicant?
Yes. Was it your testimony that after you received that letter in November, you did continue to rent?
Yes, I did a handful of times, probably 2 or 3. Mr. Osborne is correct with December.
Sure, I understand. And did Councilman Withers know about that?
He did know about that.
Right.
Okay. Any other questions? We'll close the public hearing. Discussion.
Well, we all know that Councilmember Withers is least likely to approve of anything, of any of the council members that we hear from, and he's saying he is supporting the reinstatement of this one. So that had some weight with me.
Yes, certainly acknowledge
And let me,
the applicant
yeah,
he acted.
let me read from Councilman Withers' email to us in part. I am satisfied with the account of these extenuating circumstances provided to me by the appellant, that leniency is warranted in this case. I am therefore inclined to support his request to reinstate his eligibility to return a Type 1 STR permit for this address, providing all other permitting requirements are met.
And this is a case in which it's a denial of the short-term rental permit, so we can assess a penalty. It's not just a reinstatement, right?
That's correct, up to 1 year.
And of course, the staff is always quick to note, we have a 1-year penalty in effect. The board is permitted to reduce that 1-year penalty that is presently in effect. If you're not adding anything, you do have the opportunity to subtract if you wish.
Discussion. So this is a new one. We've not heard of a divorcing couple and one, unbeknownst to the other one, basically canceling the permit, and then here he is. You know, had his ex-spouse not done that, would have had a valid permit and been able to continue to rent and operate. But as Ms. Chappell pointed out, he did know that the permit was revoked, even though not by his doing, and rented 2 or 3 times after that.
I have a hard time with that. And I do want the record to show that Councilman Withers, who has been unfailingly critical often of our deliberations, had knowledge of that, and he is in support. And I do want to be deferential to our council members, but I would tend to think he should have a 6-month penalty for coming to say he knew he didn't have a permit. He knew. We have people come in that cancel at great personal financial cost, cancel listings, and that's just important to me that people do that. So I tend to think it's in the 6-month range. I certainly would consider what you guys have to say.
Are you considering that he's already been penalized for about 3 months approximately?
I would mean. Is my thinking.
I think this is an unusual case because the spouse canceled it without his knowledge, and had that not happened, we wouldn't even be here. So I really think we should take that in consideration too, that basically, if this was one of those law school cases that, basically you didn't intend to, it's about intent, you didn't intend to give this up, someone else did, and now you're being penalized for it, even though you knew, yes, you knew.
What do you think?
I'd say around 3 or less, because the councilperson too, like you said, who's a very tough critic of short-term rentals in the district, is satisfied that, and he used the word leniency. So as John Michael would say, that's less than a year, but we get to determine what that is.
Do you have a motion?
Okay. I move that the zoning administrator erred in the denial of the short.
No, he didn't err.
The zoning administrator did not err in the denial of the short-term rental permit. But given the extenuating circumstances of the one former spouse canceling this permit without the other spouse's knowledge, that I think that the amount penalized already of 3 months should be the punishment, and he should be eligible to apply for a permit today.
I second that.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Oppose? Pass. 4-1. Okay, good. So, eligible to apply today. That means you have to comply with all the rules, talk to the zoning people, and do not rent until you actually have a permit. Good luck.
And of course, by today, we mean tomorrow, given that the zoning staff has no idea what just happened in this board meeting.
Yes.
But see you as early as tomorrow.
Okay.
Mr. Chairman, the next case is 2018-006. Dylan and Shannon Brooks are the appellants and owners of the property located at 3186K Parthenon Avenue. The request is for an item A appeal involving a short-term rental denial of a permit. I know your documentation reads revocation, but this is actually a denial of an application. The property is here, as indicated on the aerial. Face of the property here. Is there anyone here in opposition to case number 006? Seeing none, the appellant will have 5 minutes to make the desired presentation. Please just introduce yourself by name and address.
Hi, my name is Shannon Brooks, and my name is Shannon Brooks in regards to 3186 Avenue, Unit K. Thank you so much for your time. I feel so silly. We have an extra bed and bath in our bottom of our condo. We have had the permit from the beginning. We are totally compliant, and we are up to date on all of our tax requirements for our little room. We have the required extra insurance, and none of our neighbors have any issues with any of our guests who have stayed with us. It's just a small room. I'm so sorry we messed up. I really messed up. We've had a lot of stuff going on this past year. Not that any of it matters, but it's been a lot. I was diagnosed with an early onset Parkinson's. Anyways, and my husband is semi-retired from the Army. He just retired, and he's in the middle of trying to go to medical school. He's doing National Guard. He's in the Army Special Forces Unit, EOD, out of Fort Bragg. So he was back and forth. So long story short, he wasn't around all the time. So I'm used to taking care of everything by myself. Well, he was trying to be really helpful last summer. And in turn, this kind of slipped through the cracks because I thought he'd taken care of it. He thought I took care of it, but I'm not going to pass blame. It's just it happened. And he was trying to get ready to go to medical school and do a National Guard. And I was working. I own a little hair salon, and we combined with another salon. Anyways, there's a lot going on. But it slipped through the cracks, and I really messed up. It won't happen again. We spent a lot of money so far trying to get this rectified. When I realized I'm not very good at checking my mail. He gets mad at me all the time for it. But anyways, he got the letters, and he's like, "What have you done?" And I was like, "Oh, I'm sorry, I don't know what I did, but I messed up." So I talked to my lawyer, who's my client friend as well, Bob Mendez, as we've heard his name earlier, and he's on the council, and he's like, girl, you know. So I had changed it to a 30, when I realized what had happened, I changed it to a 31-day rental, just because we had some rentals out further, and I thought, well, then we can, I didn't realize I had to take it off the listing. I didn't realize that. So I just thought, well, we've changed 31 days, and I'll have this all fixed before anybody stays again. I've canceled some reservations when it kind of came up due. When I realized, then Bob was like, you need to put it on hold. So I paused it because I messed up. It was, I had everything set and ready to go, and the fire marshal came out, and then when the fire marshal came out, it took a minute for it to get back to me, and then I didn't get it fixed in time. I sent my husband down there when he came in town for the weekend. I'm like, please go down there and get this for me. And he went down there, I left it too long. They denied me at that point. He's like, you've caused a big mess now. So anyways, I'm trying to fix it now. So between all the flyers and everything else, I'm several $100s in already, and the cancellations and vice versa. So, and I do have something booked this weekend, and I've already called them and told them that if I can't get a permit before then I will be canceling their reservation. They know. So they've already got something else.
How many did you cancel before this?
About 6 after I paused, yeah. So
why didn't you cancel one this weekend?
Because I thought I didn't realize it wasn't going to have the permit renewed, so I've already called them, and it's going to be canceled.
Okay.
So, yeah, I thought I could have I didn't realize how long it was going to take. I thought I could,
Gotcha.
But then the fire marshal has to come back out, and I understand that, so I forgot about all that.
So this is one room in your house?
It's one room in my house.
How big is it? You said small room.
It's a queen-size bed that takes up most of the room, and it's got a little
Okay.
bathroom in it. It's just a little room, but it helps a lot.
Okay. Mr. Osborne, please come forward. Tell us how you heard about this, any other non-permitting requirements, and what happened here.
So this was brought to our attention by host compliance, and after reviewing this one, it looked like they did have a permit in 2015 and 2016, and they just didn't renew in 2017. So the notice went out on October 27th, and the last listing that I pulled showed reviews from December.
So how many listings were rented after the permit expired? Ballpark.
Just a second.
There were probably several, honestly, because I didn't get them. I didn't realize it.
32.
Okay. Questions for Mr. Osborne? Okay, thank you.
And I still paid all the taxes on it. I just didn't realize it.
You still continue to pay taxes?
Yes, because I didn't realize I paid tax up to date, like up until my last listing.
Okay, so you're current on taxes?
I'm current on taxes, yes.
Okay.
I'm sorry, you guys.
Any questions for the applicant? Okay. Anything else to add?
I'm sorry.
Okay, thank you. We're going to close the public hearing. Discussion.
Thank you for your time.
Yes. Another item A case.
We don't have any correspondence from Councilmember O'Connell. Is it Freddie O'Connell's district, or is it?
Oh, Ed Kendall.
Ed Kendall, that's right, 21 is Ed.
Ed Kendall. Yep.
Freddie's 19, okay.
And I don't think in the last...
But we do have one letter of support from a
Yes.
neighbor.
I don't think in the last year or two we've had a correspondence with Councilman Kendall on anything in front of us. Maybe one or two, but not many. And this is a owner-occupied one-room in a house. Item A. Anyone have a motion?
have a question to ask. So it's a revocation? No.
They used to have a permit. They didn't file the proper paperwork, which was basically a check for $50. John Michael, how do you renew a short-term rental?
A check and an affidavit.
So you basically say, everything that I said on my application hasn't changed, and here's my $50, and that's how you get your permit renewed.
In a timely manner.
In a timely, yes, that's the important part.
So it's more of an expiration of a permit, not a revocation.
It's not a revocation, as I stated at the outset. This is a denial of the new application for the new permit after the old one expired. When they came in, it was revealed that they had had the multiple operations during the period where they did not have a legal permit. That's what led to the rejection. Therefore, this case is an appeal of the denial of the new application.
Anyone have a motion? So they want to apply again for a permit because they let their other one expire.
So it's the same kind of case where we can assess less than a one-year penalty.
And they've had 3 months, evidently,
Now,
since they got notice.
the mitigating part of this, although the applicant admitted they were very sloppy in their paperwork and reading their mail, is they continue to pay their taxes on these. If that means anything. The public hearing is closed.
I'll make a motion. I'll move the zoning administrator did not err and that the applicant be eligible to apply for the permit 3 months from the date of application. So that would be March 21st.
Okay, motion's been made. Is there a second?
I'll second.
Motion has been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. So you will be eligible to apply for a permit on March 22nd. So have all your paperwork in order, and I'm glad that your taxes are in order. So thank you. John Michael.
Mr. Chairman, case 2018-007 is for Mark Thierry, the owner and appellant for the property at 244 Fifth Avenue North, suite number 101. The appellant's present and will have the opportunity to make the desired case to the board on this item. May appeal, denial of a short-term rental permit. Is there anyone here in opposition to case number 007? Seeing no one here in opposition, the appellant will have 5 minutes to make the desired presentation. Just please introduce yourself by name and address, and please correctly pronounce your last name in the chance that I did not. All apologies if I did not.
Mark Tahiri, you pronounced it correctly. 1505 Sylvan Park Court, Mount Juliet, Tennessee. I just wanted to clarify something. It looks like this was issued as a revocation, but I think it should be a denial similar to the last case.
Yeah, it's a denial.
The property that we have is a 3-story mixed-use property. There are 2 residential units and then 1 commercial unit on the first floor. I lived on the 3rd floor unit for a period of time, obtained a type, what I thought was, I applied for, a type 1 permit. We rented it out, I think, on 2 occasions, paid taxes. Ultimately, life changes. You can no longer live in a loft downtown. I moved out. I let the permit lapse because I was under the assumption it was a type 1. What was actually issued, what I found out later, was a type 3 permit, a multifamily. This comes back a little bit later. I advertised the units for long-term rental on Craigslist. A third party came to me and said, look, we want to rent it, but we want to do corporate rentals or short-term rentals. And I said, that's fine. We can do that, but you have to obtain a permit. And if I could, I'd just like to read a caveat that I had in one of the emails prior to establishing a lease with them. On August 30th, 2016, I said, a permit will need to be obtained for a short-term rental occupancy. I face the risk of fines as the owner if the short-term rental code is not adhered to. If you can send me the information on your current permit, I can review and check this off. They responded, as for the permit, I can apply for it, and typically it would take 4 to 6 weeks, and I can get the process going. They followed up on September 12th and stated, as for a start date, I need to have October 1st in order to get the unit furnished and permitted. I said, okay. They ultimately leased the third-story unit to this third-party outfit, and my understanding was they got a lease. My regret is that I didn't get a copy of the permit that I talked about, despite them telling me later that they actually had received the permit. The second floor of the building was leased long-term. That was ultimately leased to the same third party. So now they're operating on 2 floors, the second and the third floor. The existing STRP expired on May 5th, 2017. That was the permit that I had. Doesn't apply to them. They can't use it. I was contacted by Metro Collections Office, and she was inquiring why there was a different name who had paid this hotel an occupancy tax versus who paid prior. And I explained a situation that I had, and she said, oh, well, there's no issue. That struck an issue with me, and I said, hey, have you applied for an additional permit for the second floor unit? I wasn't confident. By this time, I'd become comfortable that they had a third, even though I now know they did not, for the third floor property. I wanted to find out if they had a second. So on September 28th, I asked them, please confirm that you do have a short-term rental permit for the 2 suites. They responded, this is correct. Sorry for the delay. Throughout this whole time, there were a lot of changes in personnel at this company, and I began to become more and more uncomfortable with the way they operated. On November 15th of 2017, they sent me a letter saying, we're going to form a new company in Nashville. There's going to be some other changes. I said, you know what? I don't think this is going to work for us. They couldn't assign per the lease to a new company, so I had rights. I met with a local company that they manage short-term rental properties, and they actually brought up, I believe where this image was brought up, to show me who needed to be provided notice for the new permit that I would apply for. And then when I looked on this site, it showed all the permits that were available, and I could see that they had never, in fact, had a permit. The lease was terminated with that entity shortly thereafter, and they were not permitted to occupy the premises after, let's see, I believe November 18th of 2017. Then we began the process of sending out notices to the neighbors for the new permit that we were attempting to acquire. All the way to the point where we came to codes, applied for the permit, had all the information, had notice, had consents from our neighbors, and ultimately they said, look, you got, if you haven't received it already, you're going to get a notice that you violated the statute. I received that notice. It was dated December 1st, 2017, but I received it on December 11th, 2017 via text message from the commercial tenant on the first floor of the building. Since that time, no one has occupied the premises. It's remained vacant. I have not relet it on a short-term basis or on any other basis. So I'm here today to ask for the board's discretion to allow me to reapply for the permit. Had I known that a Type 3 permit was originally issued, I would have paid the $50. I would have renewed the permit, and I wouldn't have leased it to this third party that's ultimately got me in this scenario today. So I ask for the board's discretion in that manner. The only other thing I would say is that when this period came along, a lot of things changed in my life. 2 twins being born before their time. So that was a life-changing event, but that led to some oversight that likely wouldn't have happened had that not been the case. Thank you.
So I'm curious, you own this building?
I do.
So this is good real estate in downtown Nashville on the corner of Union and 5th, right?
It is.
Why would you just go through some third-party person that obviously didn't do their due diligence as opposed to just doing it yourself or being a little bit more on top of this?
Absolutely. And the time, both of my kids were in the NICU for a period of 130 days, so my focus was on them. And to me, I thought a long-term leasehold interest would have a little bit more value at that specific time because I don't have any obligations to it. I thought they could deal with it, they could run with it. I didn't really think of management companies because I didn't want to go through the process of having an SGRP again. I've already applied for those. I know what is involved. I didn't want to do it. I didn't have time to do it. Now, things have calmed down a little bit, and I can actually look at this, and I do want to use it for a short-term rental property. It is in a commercial area. It is the most viable use in my mind.
Questions for the applicant? How long have you owned this property?
Since 2013.
Anything else to add?
I did not. I was actually just curious to hear Osborne's.
Mr. Osborne, please come forward. Tell us how you heard about this. What other non-permitting violations there might be, if any?
This one came to our attention through host compliance, and so we sent the letter on December 1st. And it looks like they took the advertisement down almost immediately and have come into compliance.
So how many times were there any?
The advertisement I had from Flipkey showed at least 2 rentals. There were some other rentals I'd found after hearing that there was 3 units and there was only 1 permit issued that had expired. So I was looking into all that. But
So there are multiple permits on this particular?
No, there was only 1, but after hearing that they were renting out potentially all 3, I was looking into that to try and get you some more information. One of the other advertisements had about 9 reviews on Airbnb.
Of this location?
You'd have to give me a little more time to figure out if it's this unit exactly.
But his ownership?
Yes, sir.
Okay. Want to respond to that?
I was just curious are you able to see who the party is that's actually doing the short-term rentals?
I believe it was U-Rent.
Okay, that's right.
So this is one of those situations you had kind of trusted somebody to kind of get a permit and rent it out, and you paid them a fee, right?
It was a rental fee. It was more like a master lease, where they had the ability to sublease.
Okay.
With the condition, and I made it very specific, and this is why I was able to, that gave me the ability to terminate the lease so quickly, is if you didn't have a permit or a short-term rental permit specifically, you're in default of the lease, and that was the default that was ultimately caused, and it was terminated.
John Michael, downtown code, all this other stuff, don't you have to own the property to have a short-term? Is that why they probably didn't get a permit? They didn't own the property?
Well, as the legal representative, they're able to get that. Think of the scenario where if, Ewing Corp has one of their huge apartment complexes here in Davidson County, and I, a humble renter, want to get a permit. As long as I have permission from the owner, Ewing Corp, or their designated representative, I, the humble renter, can come in and get a short-term rental permit. In this scenario, the entity, not individual, but entity to whom the appellant leased the subject property would have been eligible to come in and apply for and even obtain a short-term rental permit as long as they had permission from the owner, in this case, the appellant. Now, to your implied question, can't get a Type 1 permit that way, but you can get a Type 3 permit that way. It would be profoundly and deeply illegal to get a Type 1 permit in that scenario.
Okay. So tell us the difference between Type 1, 2, and 3.
I own it and I live there. That's Type 1. Type 3, multifamily structure.
Okay. Very good. Yes.
If I may, there was only one other thing. On the Nashville website for SGRPs, it does state specifically, Type 3 permit applications must either be the owner of the property or the lessee.
Okay. Very good. Any other questions? Anything else to add?
I do not. Thank you.
Thank you. Discussion. We'll close the public hearing.
It appears that 2 opposing letters are just simply opposed to
Short-term rentals in general.
Not that they have any complaint about this particular one.
And Type 3 is a unique situation, so this is like a commercial building on the corner of 4th and Union. Yes, it's that building in the top left-hand corner. See the gray roof, that's it. So And then the arcade is on the other side of the street for oriented to where this exactly is. So, this is another case of not the right management company. So, any discussion on this? Well, I will move that the zoning administrator did not err in the revocation, but we will grant them their short-term rental permit tomorrow.
It's a revocation.
Oh, it's up or down? Okay.
Again, it's a denial in this case. I'm sorry that the originally composed docket said revocation. It is a denial. You are working with a one-year wait. You can reduce that wait as the board sees fit.
Yep, that's what I thought. Okay, motion's been made and properly seconded. Any more discussion?
I felt it's a little too lenient since some of the other ones today have been 3 months from application date.
Well, the reason I thought was because it just seemed like it was a sloppy management company that just really, the guy didn't know. It's like, here, you go do this, and somebody did it without a permit, and then it's kind of, he's obviously clawed it back and just saying, should he stayed on top of it a little bit more? Yeah, no, I mean, it's just one of those things, right? So that's why I feel that way. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. He's eligible for the permit tomorrow if he applies. Good luck.
Mr. Chairman, case number 2018-009 is our next case, and it's a zoning case. Gong Su is the appellant on behalf of Shiquan Su, the owner of the property at 121 13th Avenue Circle. This is an A and B unit, again, 121 13th Avenue Circle, just south of downtown in Council District number 19. The request is for a variance from the sidewalk requirements in the R6A, or alternative zoning district, for the construction of a new duplex. The property shown here in the aerial view, though somewhat dated, does give a good layout of the circle, or small kind of short cul-de-sac. You see here the approximate length of that 13th Avenue Circle, glorified driveway, and then the aerial here. The site plan submitted gives a proposed layout of the construction. The request, of course, is for to be varied from the sidewalk requirements. You have the planning department's recommendation in your case file already. From my recent site visit, the interior of the property is shown in the lower right-hand corner. You see the existing sidewalk, which appears to be approximately a 5-foot sidewalk, about a 1-foot planter strip.
Forward? Oh, continue, John.
And then in the upper left-hand corner, the view out 13th Avenue Circle. Then the views kind of looking to the left and right from the face of the subject property, so you get a good clear view of the sidewalk that's already in place and the small planter strip. Is there anyone here in opposition to case number 009? Seeing no one, the appellants will have 5 minutes to make the desired presentation. Again, council board members, you have the entire case packet in front of you, including the planning department's recommendation. The appellants, if you'll introduce yourselves by name and address, make the desired presentation.
Yes, thank you. My name is Bob Siegenthaler, and my address is 1496 Woodmont Boulevard here in Nashville, 37215. And I'm a land surveyor, and I'm here with the owner of this property, Mr. Gong Shu. The property at 120, as John Michael said, is at 121 13th Avenue Circle, which is a cul-de-sac. And it has, on this cul-de-sac, there are like 4, as you go off of 13th Avenue onto this dead-end street or cul-de-sac, there are like 4 houses on either side. And not only that cul-de-sac, but this whole neighborhood for 13th Avenue for several blocks, 14th Avenue for several blocks, they all had this same existing configuration of sidewalks. And I've measured that. It's a 5-foot existing, a 5-foot sidewalk. And there's like a 6-inch curb, and then there's 18 inches of grass, a grass strip, and then there's a 5-foot sidewalk. Well, what this, and this is just throughout the neighborhood, and I've got some pictures of it, but I don't think you need to see them, but that's the configuration of a 6-inch curb, 18-inch grass strip, and a 5-foot sidewalk. Well, if we conform to the regulation for this particular situation, it's easily said to be disruptive, because what would then be required would be a 6-inch curb, a 4-foot grass strip, and then a 5-foot sidewalk, which would come over into the private property and be handled by granting an easement for the part of the sidewalk, which would be about 2.5 feet. Part of the sidewalk would be over on property with an easement. And that's not the problem. It's not an objection to providing the easement. The objection is, and it's a hazard, if you're walking down the sidewalk, you have a 5-foot sidewalk, and when you get in front of this property, if he makes a 4-foot grass strip, then if 2 people abreast are walking down that sidewalk, the one closest to the curb is all of a sudden going to be walking in grass and not on a sidewalk. And if the whole neighborhood was that way, or this cul-de-sac was that way, that'd be just great. But there's just block after block where this same configuration is, a 6-inch curb, 18-inch grass strip, and a 5-foot sidewalk. So like I say, it's at night, if a person is walking down that sidewalk, they'll find themselves walking on concrete and then walking in grass, for the frontage of this particular lot. So we're asking the board for this appeal, or consideration of this appeal, I should say, to permit this variance. You have something to say?
Yeah, my name is Gong Yusu. I'm the owner's son, actually. And I think Bob is explained pretty well. And actually, the one side, if based on the new regs, the sidewalk like 4-foot grass and then 5-foot concrete sidewalk, and one side the people probably will walk from the sidewalk to the grass, and the other side actually is on the slope, is a pretty steep slope, is dangerous actually. So I don't think that's if just one lot has like 4-foot grass and 5-foot sidewalk is not consistent, it's not safe, it's not safe too. So that's something I'm worried too, except what he explained. I don't know if
Any questions for the applicant?
Yes, the planning department recommended paying into the in lieu fund. Wanted to see your thoughts on that.
Oh, they want money, you mean? If that's like rules, then okay. If everybody do it, I will do it. If not, if just specifically for me, that's not fair.
No, it's rules.
Okay.
It's the rules.
Okay.
Any other questions?
I don't understand why on the front page of our application it says they're not allowed to contribute, and
Yes.
yet the planning department says we want them to
So,
contribute.
John Michael, please answer this question, which comes up
At
frequently.
risk of sounding glib, it's because they are not allowed to pay into the sidewalk fund, but that's based upon our administrative review of the permit application. We, at the administrative level, pursuant to the ordinance, 2016-493, do not have the ability to allow them to make a payment into the sidewalk fund based upon any number of conditions depending on the property, whether it be because it's on a major street or because it's within the UZO, whatever it may be. So with this being one of the properties in that example that we don't have permission to let them pay into the sidewalk fund, it is an appealable condition that they can take to the Board of Zoning Appeals and ask, would you please let us pay in? Planning Department, knowing that, has made precisely that recommendation.
Okay, any other questions? Anything else to add?
If you think a photograph would be helpful, I'll be glad to pass them around.
Sure, we'll take a look at it. Mhm. Yes.
Yes, from that picture, you can see the other side is on the slope, the sidewalk.
Okay. Anything else? Okay, discussion time. We're going to close the public hearing.
I'm satisfied based on the presentation that the variance as to not tearing out this sidewalk and rebuilding another is reasonable and should be granted, but I would follow planning's recommendation that they be required to contribute to the in lieu fund on the square foot on your frontage.
Okay, does anyone make a motion to that?
I think you meant to say linear foot.
Linear
See,
foot.
right now, you're not in, permitted. Oh, I'm sorry.
Okay.
Do you need to explain?
Let me explain this. What they're saying is, as it is, they have a sidewalk fund that you contribute.
So I need to do it?
You're not required to on this, but the board is asking, would you be willing to contribute into the sidewalk fund?
How much? If like 2 million or something, I cannot afford it.
It's
I
not
don't know.
that he's not required to, it's that he's not allowed to unless we grant his variance, and then we have the authority to take an in lieu contribution, which is what the planning staff is recommending. It's based on the footage on the front of the property, and it's a per foot fee. I do not know what the fee is.
Yeah, I want to know how much.
It's $178 per linear foot.
Per linear feet, 178, is that?
$178 per linear foot.
That's how much?
Per foot.
Yeah, let me see.
To be clear, Mr. Chairman, the board has the authority to make this motion if that's where the board is clearly heading to allow them to pay to the sidewalk fund, but that's just it. You'd be allowing the appellant to pay to the sidewalk fund. They also have the option of constructing the sidewalk as required by law. So you are merely opening the doors to more possibilities for them.
Okay. So let's close the public hearing again. Motion.
Did I make a proper motion? I thought I said that. Was that motion proper?
Okay.
Okay.
Motion. Second. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes, so they get to pay into the in lieu fund. Okay, John Michael, next case.
Mr. Chairman, the next case is 2018-010.
He'd be able to, he's required to, is that it?
Yes.
He can either construct the sidewalk or pay into the fund.
Build a sidewalk or pay into the in lieu.
Just based on the 13th Avenue circle side, not the back side, right?
No, the front.
Only the frontage.
Just the front side.
Front, yep. Okay, thank you.
Very much.
Case 2018-010 involves the property at 1513 Lillian Street. Elizabeth Birch is the appellant and owner of that property. This is an item A case involving a short-term rental permit and the denial of a short-term rental permit. Is there anyone here in opposition to case number 010? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. The aerial photograph shown here and the tax assessor's website shows this as the frontage. Please introduce yourself by name and address and then make the desired presentation to the board.
My name is Elizabeth Birch. I live at 1513 Lillian Street. I received a letter on December the 22nd, 2017 at my parents' house in Indiana telling me that I needed to stop doing the short-term rental due to not having a permit. So I called Mr. McBroom and spoke with him, and he went through the process of everything I needed to do. I then took the listing off of Airbnb, and then my parents came down to get a date to come in front of the board. And so they went in and talked to Debbie Lisby, and got the date scheduled for me to come in. And so I sent out the 144 letters that I was asked to send out for the 600 people that lived within 600 feet of my house. There was 144 letters I need to send out, so I sent those letters out, took it off Airbnb, and put the sign up in my yard as asked. So I'm here today to see about getting a permit for my short-term rental.
So tell us what happened, just in general, why you didn't have this permit.
Well, actually, so I'm originally from Indiana. Like I said, the letters got sent to my parents' house, and if I didn't go home for the holidays, I would never I would have never received the letter. But I bought my house in 2015, August of 2015. I put it on Airbnb, and on November 2015, the first time I rented out was December for New Year's. I had a couple coming down to Minnesota. I didn't realize I needed a permit. Being from Indiana up there, when my friends had their houses on Airbnb, there was no permits required. So I just got on the website and put my listing up and started listing my house.
When did you find out we had laws?
So then I found out from some of my friends that live here that have them, and I talked to one of the management companies, and they came in January 2017 to get a permit. So I had a permit put on hold, and I was just waiting for a phone call for someone to come and do the inspection, and I never received the phone call. But yes, I did continue renting my house out on Airbnb without the permit. And then I was just waiting. I thought after I got the permit that I could go back and pay my back taxes, and I just thought at the end of the year I could pay them. But I didn't realize you had to pay them monthly.
So were you given a permit at the time?
I have not given a
Then why did you continue to rent out the house?
income, paying for my house, and I travel for work, and I go up to Indiana to work, and it's just nice having people coming in and out of my house and looking like someone's living there.
So if there was a member of the council here that helped pass the legislation, they'd say, we have laws, we pass laws. You just ignore them.
I did.
Okay, Mr. Osborne, or Mac, actually, is this your case? Yes. Tell us about this case and why. When did you hear about it? Is there any other non-permitting violations?
This came to our attention through a hotline call, and I researched the ads and found no exterior pictures except for the backyard, which makes identification a little difficult, usually requires a site visit. I researched the advertisements on the 11th of December, and on the 12th made the site visit, examined the exterior, matched the backyard, and made the photographs. And there was also an interior match through a Nashville real estate website, which double verified that this was the property. On that same date, the 12th of December, I issued the notification of violation, which was sent out, and I noted that the address was in Indiana. So on the date that I went to post the stop work order, the advertisement remained up. 22nd of December, I posted both the stop work order as well as the notification of violation in case that way it would get to the person that was doing the renting of the property. In the interim period, Host had also identified it. But then shortly thereafter, I received a call from Ms. Bursch and discussed the matter with her. She took the advertisements down on December the 30th, which Host verified and did not repost the advertisements from that date until now.
Any questions for Mr. McBroom? No? Okay, thank you. Okay, anything else to respond to that?
I have nothing else. Thank you.
So you heard about it from them, the stop work basically, and you continued to rent a few times?
No. When I got a hold of him after I got the letter, when I went home for the holidays to my parents and I received the letter at my parents' house, I called Mr. McBroom and I did not rent after that.
Did you cancel future postings?
I didn't. Right now it's a slow time anyways with the winter and stuff, so people don't come. So I didn't have anything to cancel. I didn't have anything booked.
Okay. Questions for the applicant? Okay, we're going to close the public hearing. Discussion.
We do have opposition from Councilman Withers on this case. Very strong.
Unlike the other one. So let's just read in part of Councilman Withers' strong opposition. Dear members of the Board of Zoning Appeals, I'm writing in opposition to the appeal for a short-term rental permit on the property located at 1513 Lillian Street in Council District 6. He goes on to say, he just talks about basically I would further point out the applicant's own statement as specific hardship would support the variance case. In order to be a resident of Nashville, Tennessee and make mortgage payments, the Airbnb would be required to make the payments on the home. I would argue the appeal does not meet the standard of hardship not being self-imposed by the property owner. He then goes on to say, District 6 experiences a large number of STR permits, and circumstances surrounding the cases vary widely. Both the neighbors who have concern about STRs and those who are properly permitted STR owners rely on codes and, by extension, you to ensure the fair enforcement of regulations. This case appears to be one of the more egregious STR violation cases that I have reviewed for District 6, so I'm writing you to urge you not to support this particular appeal.
One thing we should point out, though, is this, he mentions a hardship and variance, and this is not a variance case. It's item A.
Is this more?
I think he was saying egregious based on his perspective from District 6, but that's just, so, but that's the gist of the district council person who we heard from in a previous case who was in support of a case for leniency. He used the word leniency, not in this case.
I guess I have a question about occupancy and his referral to the address listed on the appeal and then crossed out and put the Lillian Street address. That, do you all have any feelings about that?
I think that she said that that's her parents' address, but I think whether or not she has a proper type 1 permit is decided at the administrative level, I think.
Mm-hmm.
I'd make a motion that based on the fact that she has not rented since she got her application, got her letter, that she be allowed to apply 90 days from the date of her application, and her application was dated December 29th, 2017 for a permit.
And she'll be able to apply when?
90 days.
9 days, okay.
December 29th, 2017.
Motion's been made. Is there a second? I'll second it. Motion's been made and properly seconded. Discussion.
I think that's a little lenient because she did rent from January 2017 until sometime later in the year. So I would say 6 months, but that's just me.
So you could either amend the motion, or you could, as she said, see if the motion works.
See if the motion works.
I'll amend the motion to 6 months from date of her application.
Okay. Motion's been made and amended. Second. Okay. Any other discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? No. Okay. 4-1. So it's 6 months from which date they're
December
eligible to apply? 6 months from December 29. Okay. Good luck.
Thank you for your time.
Okay.
Mr. Chairman, having previously heard case 2018-012, that brings us to the final item on today's docket.
John Michael?
Yes.
We need a full break.
Board will reconvene after a short break.
They're here. That's all. So we got to do from the previous. So we're going to go on.
Rehear case number 2017-270, which involves a property at 3501 Murfreesboro Pike. The district council member, Jacoby Dowell, filed the motion to rehear. Our board rules of procedure, of course, specifically outline what a motion for rehearing is, what the criteria are to even consider to grant it. Normally, we do not hear from the movant. However, because in this instance, and it is somewhat unique, the movant is in fact the district council member, and because this board historically hears from district council members on just about anything, the board will acknowledge the district council member and hear from her briefly with regard to the documents that have been submitted both by the council member as the movant and by the party that was the previous beneficiary of the variance that had been granted. You have all of that in your case pack or your case file already. Before taking up the motion, it is advisable that the board would hear from Metro Legal to remind you of the legal criteria with regard to motions for rehearing. So
Okay,
if it
let's
should be
ask
the
our
board's pleasure.
lawyer, what is our criteria as far as determining whether we grant a motion to rehear or not?
So today, you're, as Mr. Michael said, you're considering the motion to rehear. The board rules specifically say that the rehearing should not be granted unless new evidence is submitted which could not have reasonably been presented at the previous hearing. So it's up to you to determine today if the evidence is being offered, A, is new, and B, could not reasonably have been presented at the hearing. It's worth pointing out we are not here to have the rehearing. If you would vote whether or not there will be a rehearing, at which point if you grant the rehearing, the motion, the rehearing would be at a later date. Today, you're only considering if the evidence being offered is new and could not reasonably have been presented.
We're only considering it orally from the councilwoman. Don't we have a rule that we're ruling on these on paper now?
Well, the councilwoman made her her motion when the previous rules were in existence.
Prior to the effective date.
And so I think, and additionally, as Mr. Michael pointed out, because she's a council person and we let them speak, she will have an opportunity to speak. I also think the rules in the way the board typically works is if one side wants to make a statement, the other side can. So because of the circumstances that this is a council person who filed her motion under the previous rules, she will be allowed to speak. Therefore, the other side will be allowed to speak as well.
Councilor Dowell, please come join us, state your name, your address, and what you're asking for us today.
Thank you. I am Council Lady Jacobia Dowell. I represent District 32 out in the southeast Davidson County area. And I'm here before you today to ask for a request to rehear 217-270. And if I may, first I just want to thank you for the opportunity to have this ability to ask for a rehearing. I really appreciate that. As you probably already know, I was not able to attend the last meeting. And I shared this is my first time having a situation where a person is really non-compliant to something. Usually I'm able to work things out with them, with the board, with whatever, but this is a different case. But I did listen to the case when I was in Charlotte over the internet, and I just want to point out a couple of things. Is that it was stated during the hearing that I had requested a deferral, and I think Chair Ewing mentioned that isn't this the case we requested a deferral on, and then I think the attorney said yes, and I think she's had multiple deferrals. And I just want to point out to my constituents and also to the public that that's not true. I've never asked for a deferral on this particular case other than the one time when I was in Charlotte. And there was some misunderstanding about who I request to have the meeting deferred. And I just want to say this, if you allow me this privilege, is that I brought this case up like in October of 2016, and it has gone from like planning to BZA planning, and so that's probably why we've had this confusion about the deferral going back and forth and who requested a deferral, but I never asked for a deferral, and that's why I'm asking for a rehearing, because I did have petitions that neighbors signed in the meeting. They didn't know that they were supposed to send it to you because there was a lot of misunderstanding, miscommunication there, but also in the hearing it was said that the neighbors, that Jacobia, I think I heard the attorney say that I was the only one to care about them. That's not true. I wouldn't take a PTO day off and sit down here 4 hours just because I care. The only reason I get involved in a case is because neighbors contact me, and they have been contacting me since 2016 about this. I did go to the Planning Commission, and you asked why it was switched over and it was moved. I think that was at the request of the Planning Commission, like Carrie Logan or someone with the Planning Commission and maybe with the BZA about where to hear it. I don't know who granted the deferrals back and forth, but it was not me. I just looked on the schedule and showed up when it's time. So I just want to make that clear that I did not, and I tried to communicate as best I could to the people about.
Well, thank you for clearing that up, but as our lawyer just said.
So I'm going to get into that about, you know,
new or
the new thing. The new thing is that One is that I never deferred this. That's the first thing. And so the new evidence is I never asked for this to defer it. I never had opportunity to come and to present my facts before you along with my neighbors, because we went down to the Planning Commission, and we got down to the Planning Commission. They said they did not know whether or not they should hear it at the Planning Commission. They voted against it, and then they said this is not a zoning issue. This should go to the BZA. But we went down there, and then it was deferred, and I did that 2 times. I left my job, I went down there twice, and it was deferred. And then I came here. So I think, I never got an opportunity to present anything because it was deferred, not by me, but by whomever. I don't know. But the thing that I want to point out that I heard that, like new evidence or whatever, is that, one, it was not known to me at the time that this is a 10-year lease. And a 10-year lease is not temporary. And the other thing, the way that it was presented, is this is a mobile car wash business, and this is not mobile. We have an overlay. And our community worked about 2 years to establish this overlay. And it's personal, I guess, because many of us paid for it out of our pocket. Council Lady Karen Johnson put money up, Councilman Duvall put money up, and I did, and we worked with our neighbors to set it up. And I'm not going to rehash, but you have the reason why we set it up. If he was operating in a temporary purview, everything would be off of that lot when he leaves. As of today, there's 2 structures on that lot permanently attached, and there's also a porta potty sitting out there. And also, this is unrelated, but there's a food truck sitting out there. And what it is unfair to other businesses when you have permanent things on a lot. So what he presented to you is not true. He said he's just out there a couple of days a week, and that's not true. He's out there more than a couple of days a week. There's permanent things on that lot that should not be there, and it is a deviation from the law.
Could you tell us what those permanent things are?
Yes, there is a shed that's attached to, first of all, if it's temporary and mobile, you don't go out there and pour concrete. That's the first thing. And again, I've spoken to them all along this process, but if you can see these pictures, because I took some this morning when I went by, and I'm sorry you don't have this because I wasn't here to send all the petitions we have about this, but if you can see this, there is a shed, and if you drive by today, it's permanently attached to some concrete that's sitting on this lot. There is a wooden structure that they've constructed on this lot. They've made landscape on this lot that is not in compliance with what we do. There's 2 cuts into Murfreesboro Road and Mount View Road that is not in compliance with our overlay. And I could go on. You go out there and take a look yourself. I mean, it is. This variance is contradictory to our Murfreesboro Road overlay. And since this has been granted, just to let you know, now I'm dealing with the non-compliant issue all down the corridor again. And that's not fair to me and to others. And I sent you a letter, and the thing that I said is that 1, 10 years is not temporary. Number 2, there is no termination date on this lease. It's 10 years, it's open end. And it's, we've been through the thing about a car wash and a car mobile thing, but there is no hardship for installing utilities. I have 2 companies moving down there that's installing utilities right now on the lot. We have a Taco John that's moving in, and also a Checkers. They're connecting to the water line. So I think that was misrepresented, that there's not sewer access. There's sewer access, but you have to tap into it. So that is something that was not true. That's new. There is sewer access. All you have to do is run a sewer line and tap into it. Murfreesboro Road Publix is not on sewer. I mean, they're not on septic tank. They have a sewer access. They have a water line. So across the street, there's a Thornton's going in. They'll be tapping into the sewer line. So they don't have an issue. So this gentleman should not have an issue. So that was another misrepresentation that was stated here. And he said he just puts up tents, and that's not true. Like I said, there's permanent structures on the site. There's a garage set there, concrete poured. You talk about like access, or what have it, temporary access, or he said something about like they're going to operate a couple of days a week. There's nobody there to oversee a couple of days a week, and then when the weather was nice, they're out there every single day. So that's not true. And as I said, I want to go through this and make sure that I didn't mix anything. But they also, we talked about detailing but they are using water. He's using water on there, and there is no water runoff plan for what he's doing. I sent pictures about the number of cars that come there and so forth. But in general, I just want to say that, one, I'm asking for this rehearing because, one, what they presented was not right and not correct. As the board has stated that, I had deferred this multiple times. That's not true. I have never deferred this. I asked for one deferral, which was not granted at the time you made the ruling and had the hearing. And I would like the opportunity to bring my neighbors in. I saw that they had a list of people who had signed a petition, and I went through that. Most of them are not voters, but I went through and I talked to my neighbors and let them know, because they're still asking, like, well, why is this shed still here, and why is a porta potty here? And what about our overlay that we spent all these years working on? Why can't you do anything about this? We have people that wash car wash, so it's not about me not wanting somebody to be in business, because if you go to Bell Road, we have plenty of mobile car washes. They come and they worked out a deal with the property owners. They're in vans, they wash cars, they clean them off, they clean up their stuff, and they leave. This is the only area in our community that we have an overlay. And we put it in place for a reason. And, some people, you grant a simple variance, but it really changes the essence of the community. Like, people feel like now we can't even have an overlay. They wouldn't even allow you to come and present facts because they changed the dates, and then they misrepresented and said that I changed the dates. So those are the things that I'm presenting for you, is that I would like to have an opportunity to come and present it. The Planning Commission said this is an odd situation, and that's why they sent it back to BZA. And then it was sent back and forth. I don't know how odd it is, as far as, I don't know why we're even before a Board of Zoning. This is a planning issue. Either you're complying with the plan or not. We shouldn't even really be in the BZA. We should be in planning, and the planning should say, does this car wash comply with the car wash code, and does it comply with the zoning standards that we passed? And Mr. Adams, he agreed to. He didn't have to agree to put his property in here, but he did. And so I think when we go back to that, I heard him say he's putting a structure on it. There's no structure been put on, nothing out there. It's just not compliant. It's it's not, and I think that, I would like to have a rehearing to bring my neighbors in to let them, present to you if this is where this case belongs, and also for me to present their side of this particular situation. And I'll get off my...
Okay, questions for Councilor Dow?
I'm just thinking out loud, and I know we're not hearing the case, but why can't it go to back to Planning Commission?
So the urban design overlay deals with design guidelines, and because they're not proposing to build anything, there is not a design to be reviewed, which is why planning did not handle the case or review the case.
But there is building on it. There's a concrete poured on it. And there is a structure that's set up like a little house on it. And there's a wooden enclosure on it. So those are building structures on it. They're not temporary. It's not like a pop-up tent that you can close and take off. These are things that they're sitting on that lot 7 days a week, 24 hours a day.
Is the way to appeal something that the Planning Commission decides, is the way to do that to go to court? Or is there a metro way to do that?
If the Planning Commission rules on something, it would be appealed to court, yes, if it's something that the Planning Commission is the final decision maker on. I think all of this was discussed at the previous hearing, and it was with respect to why it was referred to the BZA. And with the BZA, again, any decision from the BZA could presumably be appealed to court. But yes, with respect to the Planning Commission, if the commission makes a decision and it is a decision that they are the final decision maker, it would be appealed to the court.
I don't know if I can say something. What was said at the Planning Commission meeting by Doug Sloan, they said this is unusual. Councilman Bettany made the same recommendation because he said variances are usually issued in hardship circumstances. And so the whole issue came up with temporary and what constitutes temporary. And I think we're all under understanding if it's temporary, it's something that comes and then they leave and there's no trace of it there. And it just comes temporarily. It's not something that is set up and established on a piece of property saying I'm temporary because I don't have sewer lines and that's why I can't build a building. So Doug said, he said, this is an unusual case. He said, I'm going to send this over to BZA to get an opinion. And they also sent when I was there, they said, we're going to recommend disapproval because if they attach something to it, it does not comply with the urban design overlay. And that was what Justin Wallace said. He said, disapprove the variance request and any associated variance request concerning a waiver. And then Mr. Herbert, he said the same thing, that that just based upon what he observed, saw, and heard and read, that he would not grant a permit on this because it did not comply. And so it's just kind of gone around.
Any other questions for Councilor Dowell before you hear from the other side? Okay. Thank you for being here. Mr. Bailey, please come forward and you can tell us your client's side of this too.
Thank you, Mr. Chairman, members of the board. My name's Nick Bailey. I live at 4700 Elkins Avenue, Nashville, Tennessee.
And Mr. Bailey, as you know, we're here to decide whether we're going to rehear this case.
I was going to try to limit my remarks to what the rules require, but there was so much said here that, I wanted to clear up just a couple of things. The reason this matter got deferred a number of times and the reason it went to the Planning Commission was at the insistence of Ms. Dowell. And there's all kinds of paperwork. There's a paper trail that will confirm that. She insisted, even though the zoning administrator told her that this was not something that needed to go to the Planning Commission because there was going to be no development of the property, that it was clearly in the purview of the BZA. She insisted, and so then it got sent there. There was an initial report by staff, which she referred to, but that was not the final report. The final report was just the opposite of that. So in spite of all that, this got deferred, so we had to go to the Planning Commission. Ms. Dowell was there with the same two people that came to the BZA hearing that don't even live in the council district to oppose it. And the Planning Commission properly found that it was not anything they needed to do anything on. It was clearly the BZA's decision. So it was referred here. We had a hearing. Every single thing that she talked about was thoroughly discussed, and I'm sure you all remember it. At the hearing, there's not one bit of new evidence that's been presented today that would require a rehearing. And I would ask you to deny it. I don't want to belabor the point and take up a lot of time. I would just submit that there's been no new evidence submitted.
Any questions for Mr. Bailey? Okay. Anything else to add?
That's all.
Okay.
Mr. Bailey, is it also your contention that the items discussed could have been vetted at our hearing in November?
Not only could they have been, but they were. And whatever caveat she's trying to bring into it could have been. And that request for a deferral was not even made. You know, if that had been made, if her request for deferral had been made several days before, I would have agreed to it. But 2.5 hours before the hearing, you know, I just thought it'd been deferred so many times, and we covered every single thing that she's talked about. So, yes, I would agree with what you said.
Okay, we're going to close the public hearing and discussion on whether to rehear this. And as our lawyer reminded us, the kind of standard is new evidence or evidence that could not have been reasonably discovered during our last meeting. So that is the criteria that we are supposed to look at whether to grant this.
Well, I was not present for the hearing that you had on this, and I have not watched it and I need to go back and watch it. But I did watch the planning meeting where Councilmember Bedney spoke about it, and I heard enough here from Councilmember Dow to be gravely concerned. I live very close to this property. I see what Ms. Dow just said to be true. There are permanent structures. There is concrete. I don't know about any other issues. I do know that from my own eyes. I see it daily. But I have mixed feelings about these these deferrals. I don't know the truth about that. I think we would have a paper trail that could prove that. And I guess I would be inclined to ask for a rehearing or to support a rehearing.
More discussion?
No, we had this hearing back in November. Have those structures changed since then?
No, they've been there for a long time, in terms of years, not months. I've noticed new plantings. I noticed that one day recently that there were some plants that had been put in there. But I often go by there and there's a barbecue pit and smoke rising, and there are all kinds of businesses going on that property.
In the pictures we were given, I don't see these structures, although it's hard to see these pictures. But I was looking at one that looks like a very clear building pad with a temporary porta potty.
I was by there yesterday, and they definitely were there.
No, I'm just saying we were shown something where I don't see the structures. So.
I saw them yesterday.
Yeah, no, not the meeting. I guess my point was, at the time we were given the information, it didn't seem like there were permanent structures there.
Yeah, so to review kind of where we are, just like we hear cases here all the time, applicants kind of have the ability to, if they don't like our opinion, they could go to Chancery Court, or, as in this case, they could ask us to have another hearing and rehear the case based on new evidence or evidence that would not have been able to be found when we heard the case originally. So this is asking for another chance at this case, if you will, because we've ruled on it.
Well, to me, the fact that we're hearing that there's structures that are permanent on the site that I can't see in those photos that we were originally given makes me think there is something new.
Even though that Ms. Sanford said that these structures have been there for years.
Well, I don't know if she's allowed to testify that, but and I'm not taking away from you, I'm just saying in my head, that's new information because I have not driven by that site, and that what we were given at the hearing appears to not show those structures. So I'm curious about those structures. I don't know if they were obstructed from the view of the photos we received. I don't know. So to me, that's a question. And
there was one little structure, like a garage kind of structure, and then a porta potty, I remember from the
maybe you all saw it and I didn't see it, but
well, then several months ago, there was like a double garage, and then suddenly it got moved, and then the concrete got poured, and then a single garage got put there. And for months, at least 10 months, and maybe a year, I have seen this wooden structure like a place to store things, and often then the barbecue grill is pulled there and barbecue smoking.
Can I ask Alma about the picture?
I would say the pictures that I'm looking at, and I had not seen these before, this is not an accurate representation of what I saw yesterday and what I have continued to see for at least a year.
You can consider the pictures today for the limited purposes of determining if it's new information, and B, information that could not reasonably have been presented at the time.
So the question is, if the structures were up there during our last meeting, that obviously could have been reasonably, discovered during our meeting by either side.
I think so. I mean, it is concerning to me that we would have a council member come in and have the suggestion that evidence that we heard was not true. At the same time, there was a hearing date, and I feel like those matters could have been addressed at that hearing. And to come back now, 90 days later, without truly new evidence, I'm not inclined to think this is grounds for a new hearing. Although it is concerning to me that we could have been misled. I think that's true in any case. So those are my thoughts.
Does anyone have a motion?
I would like to move, I don't know if I can get any support, but I would like to move that we allow this case to be reheard.
Okay. Motion to rehear. Is there a motion to rehear been seconded? Discussion. Seeing none. All those in favor of the motion to rehear, say aye and raise hands.
Aye.
Opposed? Abstain?
Abstain.
2 in favor, 2 opposed, 1 abstention. Does anyone want another motion? Not that it would be.
Are you going to abstain on any motion, if you don't mind me asking?
No,
You're not going to vote on any motion?
I wouldn't think if there's something that's not done right, wouldn't code appeal that. I think that.
Okay, I'll ask for another motion, or we can just go to the next meeting. Is there another motion?
I'm going to make a motion that we deny the request to rehear.
Okay, motion's been made. I'll second it. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Raise hands.
Aye.
Opposed? Abstain?
Abstain.
Okay, 2-2, 1 abstention. John Michael.
Under the board's rules of procedure, namely Rule Number 10, Post-Hearing Request, Subsection A, Request for Rehearing, Item Number 6, the affirmative vote of 4 members for the motion is necessary to grant a rehearing. With the motion not having obtained 4 votes by law or by board rule, the motion is not granted. Therefore, there will be no rehearing of case number 2017-270 pursuant to the board's deliberations today. That concludes the motion for rehearing matter for case 270, and as that is the last case of the day, that will conclude the BZA meeting for February 15, 2018.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.